May I please, Your Lordship?
Yes.
Your Lordship, item number 109, my lord. Client have instructed that he is not willing to contest the matter. The same may be dismissed at non-press, my lord.
109. Learned counsel for the petitioner. What is 109 is what? Appellant.
Yes, my lord.
Seeks leave of this court. Learned counsel, write her name, learned counsel for the appellant submits that the appellant does not want to prosecute this rate appeal. She therefore seeks leave of the, not rate appeal, intra-court appeal. She therefore seeks leave of this court to withdraw the same. The appeal is accordingly dismissed as withdrawn.
Right, my lord.
Yes.
And the subject property is still survey number 57. The subject matter CS7 of 58. Listed tomorrow, Your Lordship.
Tomorrow. Yes, tomorrow.
And permission urgency in the matter, Your Lordship. WP last month it has to be.
Huh?
Last month it has,
Huh?
Your Lordship, with regard to the refund of the medical expenses of the petition.
What, it is fresh matter
No, it's already listed.
pending. So then file an application for urgent hearing, madam, if you want early listing. We don't list it by this mention memo. Yes. Huh? Ah. $31.10. Yes.
Lordships can, but my lord, it's IA filed to review the order in WA 298 of 2022, my lord.
Huh?
IA has been filed to review the order in WA 298 of 2022, my lord. Lordship.
What is the urgency?
The urgency is that it is with respect to building permission, my lord. There is a threat of demolition in the matter. There is a threat of demolition.
Review what has been held. Your petition has been dismissed.
Yes, my lord.
Ah.
What has happened is my
When did you file the review?
review was filed, my lord, last week.
Last week. It has not come up.
No.
Why? The rule is that the moment it is filed, next day it should come up. That means office objections.
No, my lord. It is numbered also. IA has been numbered.
Then why it is not listed?
Which may directed to be listed at any.
1710.
Obliged.
Lordships kindly minutes. Let's take to the Lordships in this matter pertaining to not extending the reservation under sports quota for MBBS and BDS courses, Millets. My lords already heard this matter on last week of August, Millets, and the matter is Millets last phase of the counseling is carried out, Millets, in the university, Millets. Is a very threat of Millets. Is a matter is covered by the orders also, Millets.
Covered?
By
No, what we want, final hearing, that doesn't happen through memo. File an application for early hearing.
The present writ petitioner is challenging the non-local status given to him in the ongoing PG medical counseling matter. We have challenged it through that petition and it's supposed to be listed on 4th week of September. The urgency in this matter is, my lordship, that the third phase of counseling is currently going on. So expeditious disposal of the writ petition is
Expedition, so you want final hearing?
yes, they already
We
filed.
know an application for early hearing. This is not, we don't repeatedly, every day we have to tell all of you. And that means the message is not being this thing, that we don't fix dates for final hearing through mention memo. Yes,
May I be
please
permitted?
move an application.
May I be permitted to move a lunch motion, my lord? Two matters, medical admission matters. The petitioners were given a seat in the second round of counseling.
Third gender status.
My lord, it's a different matter.
Ah.
They were given a seat in the second round of counseling.
They have all the cases of third gender status, so we thought that
No,
again
It's
third
a different
gender
matter,
status.
different subject matter rule.
Ah.
They were given a seat in the second round of counseling. The hospital failed to upload the joining letter on the MCC portal, due to which their seats were allotted to different candidates in the third round of counseling. Now we have communications from those candidates also that they don't want
Who
those seats.
appears, I mean,
Central government, my lords.
no, no,
MCC
they
is the
should-
central government.
supply them a copy and ensure, we take it up tomorrow then.
Your lordships may have it today because tomorrow is the last day and those seats will be allotted in the stray round next. And today is our
When is the stray round?
tomorrow. I mean, tomorrow is the last joining date for the third counseling,
No, stray round, I mean, they will be allotted in stray round, right?
Monday.
So we can take it up tomorrow, right?
There is an urgency, my lord.
No urgency.
Let them get it. Let your lordships may have it today.
They should-
Let them get instructions meanwhile.
Instruction what? You have not supplied them a copy. They don't know anything. He will stand like this and seek time. What is the use? Let him have You supply him and let him, you find out, Mr. Praveen Kumar. We'll take it up tomorrow.
There's also a private respondent, my lord. Your lordship may permit me to give them the intimation of this writ for tomorrow in advance, so that due to paucity of time, we might.
We don't know of a procedure of this where admission, who will decide? Private respondent will
No,
decide
private
that
respondent
whether
is the
you should be
hospital.
admitted in
No,
the
private
this
respondent
thing
is the
petition.
hospital.
You give him supply, take him, give him copy and get an order from him. Why to come to the court? This is a procedure which is not known, madam. At least I have not
I
known.
apologize.
I mean, that before filing of the petition, it's your choice. There will be no order of the court.
No, your
Because
lordship.
whatever we say, you say that the court directed me to do this, court directed. You are putting words in our mouth, and then you will say that the court directed to do us to serve respondent number 2. I am not aware of any such procedure. You please tell us where is the provision in the rules that
Your lordship
before
may have
this thing petition is, it should be served on Friday. It's your choice. We will not direct anything. It's your choice to serve.
Your lordship may have.
Yes,
My lords, this is pertaining to the police recruitment. my lord.
tomorrow.
The yesterday results was announced, my lord. Actually, this honorable
Reasons were announced.
announced for the police constables. my lord. Actually,
What do you want? Final hearing, all of you,
my lord,
final
I
hearing.
filed the early date.
Early hearing. So it will come up for orders on early hearing. It will come up on a day. We will fix a date on that.
Yes.
Not like this, that we can't hear just because the result has
So,
come.
my lords, the problem is, my lord, they
No
issued
problem.
this honorable
17th October for early hearing. Yes.
Your Lordship,
Orders on early hearing. We will decide on that day which day to be heard. Yes.
Your Lordship, mention against administrative. May I got submission, my lord. Actually, they issued this honorable court. They won't.
That is what, I mean, you want that right now it should be allowed along with copy and they should be sent to jail for forever remaining part.
Any date next week would be serve the purpose.
We have given a date. We have given a date for early hearing. Yes.
It's a mention.
Whatever date was mentioned.
Is a mention, your lordship.
No mention. What, it will be called, case will be
Your
called.
Lordship, this is mentioned regarding the administrative side. Your Lordship, this is a matter pertinent to serious.
Administrative side?
Your Lordship, this is a matter pertinent to your fear.
No, you have to, Mr. Administrative side mention cannot be made in a
Your
division bench. You talk to registrar judicial
Of
meeting.
course, from last 1.5 months, your Lordship, I am approached and given a letter also, your Lordship, the matters are not being listed. The matter pertains to year of 2005 to 22. At any bench, these matters are not being listed, your Lordship.
You approach him, he will look into it. This is not the forum, Mr. Making a complaint before division bench, most inappropriate. And we thought that you are a sensible person who knows. This is most inappropriate thing that you tell us why we should not penalize you for this. You should have given, written a letter, like, I mean, address, communication.
I have written a
No,
letter.
this is not way. This is, you are insulting his lordship. This is a division bench. Can you mention a matter in respect of which I have to take a decision before a division bench? This is not proper. Yes.
My lord's application.
You meet him, it will be, action will be taken today. This is unique way, right? Mention and then get instruction. This is not fair, Mr.
Last 1.5.
Not fair, not fair. We repeatedly telling you not fair. Not fair on your part. This conduct matters. Cases come and go, but conduct and your stature as an advocate matters. You have told by your conduct something about yourself. We will remember that. Yes.
So I beg to make a mention, my lords. I beg to make a mention
Your Lordship, for this.
No, this is unfair.
Your Lordship,
Unfair.
3 times
Yes.
we have approached that
for
side.
fixing an early.
No. So therefore, you with 3 times you have approached. There is no other means of this thing. No other means of sorting out a problem except to make a mention before division bench and make a complaint against registrar judicial. Orally, this is what you are doing. Unfortunate. Unfortunate. Any youngster would have done it, we would have understood. We thought that you are a sensible lawyer and you understand. Unfortunate. Yes.
Application seeking fixing of an early date.
12:10. Yes, next. Huh? 17. All cases to your liking cannot be heard because client is pestering you, right? You come at in this thing when the motion cases are over and 2005 writ appeals are taken. Yesterday, we have delivered judgment in a PIL of 9798, remanded by Supreme Court in the year 2006. You tell us what is the fault of a person waiting patiently for 18 years, and there the lawyers seek adjournment. Here you just want because you have not been granted interim relief, so I should get the interim because client is sitting on your head. He is telling that you are unable to get it listed, so you are pestering all 2023. So it should be the reverse order. Like the concept should be the one who files the petition for later should be decided first. So like we should evolve a system and try to do it according to you that if you have filed a petition today, the endeavor should be in 48 hours, it should be disposed of. This should be the endeavor. This is what it is.
Actually, not there was a.
Yes. I think enough. Yes. 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 So correct order. There is no need for, we only can say that this issue shall be decided without being influenced by the order after framing of the issues on merits by the commercial.
The trial has started. The problem here is after the framing of
So
issues.
you want an order on merits, we will pass. No problem.
Only in our lordship may
Nothing.
1 minute, my lords.
Yes, yes, go ahead, go ahead. Please, you have a right to ask me.
The trial has started.
We have read it, Ms. The file, you tell us why, how any issue with regard to non-joinder of necessary parties, a plaint can be dismissed. The suit is for declaration, the plaintiff has dominance letters, plaintiff decides against whom he wants to contest. How can you say that such a such person has not been impleaded, therefore the suit is barred by law?
I'm not asking impletion, my lord. There is a problem. The case is, my lords, I am a supplier of a machinery. Dependents to 3, 4, 5 has 3, 4 has to pay me the money for the machinery and I have to supply the machinery. After framing of issues, he withdraws against dependents 3 and 4. His main prayer 1 is that
Suit will be dismissed if non-joinder of necessary parties. Why should you worry?
he has withdrawn after trial started, my lord. That's what the point is. After trial starts, in the chief examination, he only goes for.
He will not get any relief. You should feel happy.
He's asking.
If I would have been in your position, we would have advised the client to wait quietly and wait for dismissal of the suit.
Yes, but I agree, my lord. But the problem is, he is asking damages on me, not paying the money.
He can ask anything against you. No law can prevent filing of a suit even if it is frivolous. You don't have any immunity from legal proceeding. Under which provision of law? That no suit can be filed against you.
The suit is, that's what the doubt is, my lord, because he says he has withdrawn against 2 and 3 minor financials.
Sorry.
And he has amended this, without amending the suit, he has withdrawn. And
Anything else? Yes, heard. This heard on the question of admission in this petition under Article 227 of the Constitution of India.
Appellant is a state government and a central government owned, my lords, colliery with, my lords, coal mines and power production units across the state. The first respondent trade union, which is one of 15 trade unions in the appellate, filed the writ, my lords, out of which the interim order is impugned before your lordships. The writ, my lords, merely sought a direction to conduct the elections, my lords, to have a recognized union. Before it,
That was done previously also.
my lords, there was a direction issued and time was extended on account of the fact, not that the upcoming state elections were to be held. May I just take your lordships to the previous order before going to the impugned order? Page 42, my lords.
No. See, Mr. If despite previous directions, if elections were not held,
Lordships.
what is your remedy to file another application?
We sought for extension of time. The impugned order before your lordships rejects our application for extension of time to hold the election soon after the state elections. And the reason is the state machinery, my lords, is involved in the conduct of this election. There are 6 districts and 43,000, my lords, voters by secret ballot, and more than 700 officers of the state are involved in this election. And in fact, that was the ground on which the earlier extension was.
Who has to hold elections?
But the election is conducted by the 6th respondent. That is the.
All right, you supply a copy to 6 respondent, then we will see. Are you appearing? Are you appearing, 6th respondent?
6th respondent, lordship.
Are you appearing?
Yes. Whose election has to be conducted by the 4th respondent. I'm so sorry. The RO, my lords, the RO is the DCLC, the Deputy Chief Labour Commissioner.
Yes, Mr. What do you say?
Earlier, last.
See, Mr. Despite directions, right, of the court, and despite extension of time, if the elections have not been conducted, for your inaction, why? What you tell us, you seek instructions on this and come up with a statement within how much time will you, because elections are required to be held, right? You seek instructions.
Page number 52, page number 54.
54.
Page number 54, there is a direction from Sal Court, IA 3 of 2023. The operator force,
No, whatever, Mr. This is only against an order. He was seeking extension of time. So, presumably, as we can make out that due to whatever XYZ reason, maybe unavoidable reasons, you have not been able to hold the elections.
we are really, we have to comply with the directions of the Supreme Court, in IA number 3 of 2023. Schedule has been done. Schedule has been done. They are not cooperating. Neither the management will.
They have.
Not the government. It's not cooperating.
I didn't make this aspect clear. Page 54.
54. Yes.
An earlier order passed by the learned single judge.
Yes.
Took into account the fact, my lords, that the Telangana State Legislative Assembly is upcoming. Page 54 at 56, my lords.
Yes.
The third line.
Ah.
Learned additional AG has further submitted that on such requisition by the RO, several district collectors have expressed their inability to adhere to the election schedule proposed by the RO, citing several reasons. Inter alia, it was stated that enumeration of voters for the general elections to the assembly to be held in 2023 has commenced, and the entire state machinery and officers of several departments are being trained for ensuing general elections, and their services are being drafted for election duties. And some of the DCs have also stated that special arrangements need to be made, as some areas of Singareni collieries come within the areas having influence of Maoist extremists, and requested this court to defer the election process to be commenced from 1/2023, so that the process relating to the upcoming general elections in the Telangana State Assembly could be completed. This was accepted by the learned single judge, my lords, in this last penultimate paragraph, holding that since, my lords, this is the circumstance, the extension is granted, my lords, till October. In the interim, my lords, the Election Commission of India has notified, my lords, the schedule for the state elections to be held. Now that at page 472 stipulates 7/12/2023 as the tentative date, my lords, for elections to be held. Accordingly, on the same circumstances in which the earlier extension was granted, we went back to the learned single judge, as also, my lords, the state government, saying, since all the officers are now, my lords, required to be involved in the state elections, kindly defer it for a further period, my lords, of maybe a month or so after the state elections. That has been rejected by the learned single judge. And this election, my lords, 13 out of the 15 trade unions have also written, my lords, to the respondents saying, please defer it after the election.
Lord, with due respect,
So therefore,
it is not like that. Lord, all of the Lordship may kindly see the minutes of the meeting.
We are only issuing notice, you seek instruction.
Very well.
We will hear.
Very well.
the second
Mr.
respondent may not, my lords, the writ petitioner may not precipitate matters in the meanwhile.
What, he will seek instructions, it will come up after a week or so.
Very well. Lordship.
Mr. Aditya Sondi, learned senior counsel, so and so.
Please, Your Lordship. I appear for the writ petitioner in this matter.
Yes.
My lord, at the outset, my lord, I apologize for bringing up
No,
the
no.
petition before.
Yes, his application is pending, seeking.
No application is pending, my lord. There is no.
No application is pending, Mr.
My lord, appeal is filed before the appellate authority. It is pending.
Appeal.
Appeal is pending, appellate authority is not at functioning. My lord, appeal for the, but their prayer is not. Application
No,
is
no, Mr. But see what is this thing, prayer, which you go by what you have said in the petition.
My lord, I would
Not
make
passing any order on the application submitted by CFE, CFO, illegal purpose, canons of justice. And they are saying that there is no application pending.
my lord, I would make this submission. My lord.
Ah.
In fact, my lord, the more of a grievance of the writ petition as it appears for me is the non-constitution of the appellate authority under the Water and Air Acts. When
Ah.
the term of office expired on 4/8/2023.
Mr. Counsel, then the prayer should be like that, right?
No, no,
Ah.
it should have been like that, but
Ah.
I would only.
So you amend the prayer, then we will of course deal with it. First amendment.
I'm only submitting for your lordship's consideration that
Huh?
there was an
No, but
earlier.
this is not a PIL, nothing so moto. What is why which?
I quite.
But this is you are only saying that your application is pending, that is not decided. They are saying that the no application is pending. So tell us which date you submitted an application. Where is it?
Those applications I shall place it before this honorable court, my lord, because I didn't want to bring down the constitutional court's functioning to the consideration of an appellate authority.
No, but this is, Mr. Please see, I mean, then you make a prayer like this. We are dealing with the prayer and then you are saying constitution. We don't like. But you file such petitions. Yes.
My lord,
See the prayer clause. You are appearing, you have to take responsibility. I mean, what is the prayer? The court should not be by prayer courts.
True. No, I'm not for a minute, my lord.
What?
Prayer may.
What is this? You have made a prayer. They will adjudicate this. They have taken a stand. No application is pending. If it is found that no application, we will impose cost on you.
My lord, I'll
Misleading the court and wasting the time of the court.
may I make one
Yes.
submission. My lord? I'll ask the writ petitioner to withdraw the writ petition, my lord, with the liberty to file.
Learned counsel, senior counsel for the petitioner, after arguing the matter to some extent, see. Accordingly, the writ petition is dismissed as withdrawn with liberty as aforesaid. Next.
Lord, sir,
So where is the order you have filed? Not filed.
I filed a memo. Two of the directions I've already complied with. One
No,
is,
22nd September, you have not complied with, Mr. Order sheet of the proceeding date on which you, Mr. I mean, this not, you, the order was passed in your presence. If you don't know, we are not sitting here to tell you what is the order passed and this thing. If you don't want to comply, order dated 22/9, you want time or you, this thing don't want to comply.
Lordship, I've already applied for it. I'm awaiting that because
So how much time do you want?
after 1 week, it may be
Party in-person trace warrant is granted 2 weeks further time to enable him to comply with the directions contained in the order date. Yes.
Item 5, my lord. The application for appointment of an arbitrator being contested on two grounds, my lord. One is that the applicant himself submitted to the jurisdiction of the civil court. He has waived his right and,
They see these petitions are pending since 2017, right?
Yes, yes.
You are not in a hurry. Right?
I'm for the respond number 1 in the matter.
Not in a hurry. It will come up before me on Friday.
Yes.
Tomorrow. Let the
Instead of Friday, can I make a request, my lord?
No.
Monday,
No. Not Monday. I have to sit single, right? Let.
next Friday.
No, this tomorrow.
Oh,
2017, Mr. The institutions point at us saying that the High Court is unable to decide the arbitration applications. Please cooperate at least in these cases.
Yes.
Please, this is a block on us. Please cooperate.
Yes.
Any other case you can seek next week, after 2 weeks, I am going to US, whatever. Please do. We will not adjourn in this case. Even if you don't appear, tomorrow it will be decided. This is my promise to you.
Yes.
Yes.
I beg
Don't
pardon, my
appear.
lord. I am representing applicant, my lord.
Let arbitration application, let the same be listed tomorrow.
My lord, I beg
For a single bench, in single bench.
in this matter,
Ah.
I beg to withdraw this application, my lord.
Acha, you want to withdraw?
Okay, my lord.
Learned counsel for the petitioner, this petition under section 11 within bracket 6 of the Arbitration Conciliation Act has been filed seeking appointment of an arbitrator to adjudicate the dispute between the parties. Learned counsel for the petitioner submits that that the petitioner does not want to prosecute the petition. The same is accordingly dismissed. Does not want to press so and so, therefore seeks leave of this court to withdraw the same. The aforesaid submission is placed on record. Accordingly, the petition is dismissed as withdrawn. Next.
Next, my lord, the item.
Next, does it survive now? Next.
Yes, ma'am. It has to here since the applicant has withdrawn the first matter, my lord. CRP has to be allowed, my lord, because the application before the trial court was for appointment of an arbitrator. It was allowed, against which I filed the revision, my lord.
Yes,
It has to be heard on merits, my lord. CRP has to be heard on merits.
Out on merits, argue. This is CRP.
CRP is the petition. He's for the petition.
Yes, go ahead. What is?
Wait, my lord, the revision is prepared against allowing of an application for appointment of an arbitrator, my lord. When the
no, Mr. You don't want a appointment of an arbitrator, right?
Yes, madam.
You have withdrawn that. Now what survives in this
My lord, when the
CRP?
commercial trial court has already referred the matter to referring both the parties for arbitration, this arbitration application was not maintainable. This arbitration application was instituted because the arbitration notice was sent prior to this order under revision. Therefore, I am withdrawing this arbitration application. So far as the order, impugned order covered by this revision is concerned, my lord.
What is, yes, yes, what is the agreement dated, Mr.? Agreement is date of agreement between the parties?
It is, my lord, 27/7/2005.
Where is which page?
This page 40,
40?
no, in this matter, it's not filed, my lord. The earlier matter is
It is filed, my lord, page number 25, my lord. 25 is the arbitration clause.
page 40 of the metal papers.
20? See, madam.
26 partnership deed.
Arbitration clauses?
Yes, my lord. Arbitration clause number 25, my lord.
25. Yes.
That any of the above terms and clauses may be altered, modified, cancelled.
Clause 25.
Plus 24, my lord, pardon.
No, we didn't get the page. Which page? Which page, Mr. of this, this
According to my
this CRP, which page?
According to the metal paper available to me, it is page number 26, madam.
26.
The partnership deed dated 17/7/2005, which was marked as Exhibit A4 before the trial court.
There is no, it's not filed. It's not here in this this paper book. Other one, other arbitration thing.
At page 40, clause 18.
Partnership deed 17/6/2005.
Yes, madam.
It is page 34 in the other paper book, Mr.
It clause of 24 of this partnership deed, the page number 8 of this document, the arbitration clause is there.
Which clause? 18 is the arbitration clause.
Yes, one. 18 is the arbitration.
So then what if agreement contains an arbitration clause? The court has to refer them to arbitration. What is wrong with the order?
My lord, prior to this, there's the applicants, there's the respondents in the CRP, my lord, submitted themselves to the jurisdiction of a civil court, waiving their right under clause 18 of this deed. They have filed a suit. Admittedly, they have filed a suit. My lord, OS 1201 of 2016. Same applicant.
Mr. What does clause, what does section 8 of this thing agreement?
Yes, section 8.
You have filed a suit for rendition of accounts, right?
Dissolution of the partnership firm.
You have filed a suit for rendition of accounts and dissolution of partnership firm.
Yes.
And in that suit, the respondent in the petition made an application under section 8.
Yes.
The court has allowed.
Yes.
What is wrong with it?
Against, my lords, two grounds have been raised by me. Challenging the allowing of application under 8.
What ground?
First ground is that the partnership firm had already filed a suit OS 1201 of 2016. Partnership firm, the applicants before lordship in the other matter, they have already filed a suit.
The respondent has filed a suit.
OS 1201 of 2016. 1201 of 2016. Against because there were disputes among the partners, the firm filed a suit against the revisional petitioner before lordship for recovery of money based on the dispute.
No. So what? I mean, respondent has filed a suit. Then
OS filed a suit. Thereby giving up their right under clause 18 of the partnership deed to refer the matter to arbitration. They submitted themselves to jurisdiction of a civil court.
Parties can give up the right like
They
this.
can give up the right because they opted out of the arbitration agreement, filed a civil suit.
What happened to their civil suit?
As on that date was pending, my lord. Thereafter, no instruction. What happened? Some other.
No, so you tell us how it can be like.
Because the suit was filed by partnership.
No. So the challenge to the ground, as we have understood, is that since respondent himself has filed a suit, therefore he could not have filed an application under section 8.
Yes,
All right.
yes. There's a-
Any authority for the proposition, right?
In fact, my lord, I couldn't bring the short of time.
Huh? No time is, this is
In
what.
fact, I was relying on Rashtriya Ispat Nigam Limited 2006-7 SEC,
Huh? 2000?
2006-7 SEC 275.
Huh?
Rashtriya Ispat Nigam Limited, my lord.
Ah.
There they said that while they are going through whether the parties are giving up their right to refer the matter to arbitration or not, my lord, they also said that a clause, a mere filing of counter in interlocutory proceeding would not be a bar to refer the matter to arbitration, but the moment they take a step of filing the detailed statement of dispute, they are prohibited from invoking the arbitration clause.
The petition has not filed the pleadings in that suit, my lord. Nowhere in the pleadings in that suit, it was mentioned that the parties have gave up the arbitration clause.
They have, they
You think, Mr. Best remedy is to file review of this order on whatever grounds. If those grounds were not touched before the court passing the order, you cannot be permitted to assert.
it is then, my lord, was given in detail in the counter.
But where have you argued? Show us
Yes,
from the
madam.
order.
Yes.
Order that you have taken note of that he
Yes,
has given
High Court
up.
has totally ignored these contentions of the
Which
petitioner, my
then
lord.
ignored means then your remedy is to file review.
My lord, can my lord kindly take up page 52 of my material?
No,
My lord,
this
it's-
order tell where have you raised this contention?
Yes, exactly. That's what my submission is, my
Yes.
lord. My lord, page 52 of the material papers, my lord, revision.
No, this order is 16th February 2018, right?
Yes, my lord.
Where is which paragraph you have argued that this is given up and all this?
That was not observed by the trial court at all, my lord, but
So then file review, Mr. If a
in
contention
fact,
was
my
raised.
counter contained in detail the manipulation of accounts,
You then,
misappropriation
if
of-
you see, we will not permit the order to be assailed on new grounds, which was not.
No, we are not raised any new grounds, my lord. All these contentions are raised.
If the grounds raised and not considered, that is also, that is why we review.
I understand, my lord, but
Yes. That's why. We will grant you the liberty.
liberty to file.
Yes. Mark the presence, this petition.
It's my request for a pathway
Huh?
for the respondent.
Well, item 7, no?
Yes.
What?
Lord, item 7, I appear, my lord, lordship.
Ah.
Lord, I am for the appellant in item 7.
Ah.
I for one.
This is an after notice matter.
Yes, my lord, after notice, the matter was supposed to be, listed in June 23 for disposal.
Ah.
My lord, that's why we made a
Disposal.
motion.
No, where is the?
In the sense, my lord, it's a short question of, my lord, the.
That we will hear some other day, not today, some other day. Mr. Senior Counsel, we will hear it some other day.
Also may consider some short date, my lord. There's
19th,
some short date, lordship.
19th October, 19. Let the petition be listed for final disposal. No, but you will have to do some homework, right? Give a synopsis and this thing.
I have already
You are
given,
brief.
it is before your lordships.
These are facts in one page and your submissions in the next page, that's all.
My lord, I have
It's
already
not fine.
submitted
It
to
should
your lordships,
not,
my lord. It is there before your lordships.
taking into
Anyway,
account the nature of
19th
controversy involved. Sir, early date,
No, it's writ appeals are fresh writ appeals. Additional Solicitor General of India is.
I beg to appear, my lord, for the,
yes.
I
What?
beg to appear for the appellants, my lord, in the writ appeals.
No, there are so many IAs. So what is 3 IAs? Dispense with suspension petition and fix an early date. Who has filed early date?
We had filed, my lord, for moving the appeals, my lord, the
All right.
application
So
was filed.
map the presence heard on IA number 3 of 2023. No orders are required to be passed on IA 3 of
Provisional attachment which was passed has been set aside on the ground that the adjudicating authority, my lord, was presided over by a single member, and that single member, my lord, was not a law graduate or a person, my lord, with training in law. And therefore, my lord, it was not a proper jurisdiction, my lord, is the finding, my lord, of the honorable single judge. But, the attack was that there should not be a single member to hear the matter. If at all it is a single member who is hearing the matter, he should be a person who is trained in law. Lord, 4 questions, Lord, were framed for consideration, Lord, by the honorable judge. Lord, will kindly get it, Lord, at page
No,
number
no,
6.
so appeal has already been entertained, right? Not yet.
The writ appeal is coming for admission before your lordship. No.
Admission, all right, yes.
I'm sorry for interrupting. Now what's happening, Milad, there are some writ petitions filed on the same point. They are also listed. That is Milad, item number 11, 13 and 14. The same point is involved where we file writ petitions directly before the division bench entered the writ petitions. Now writ appeal is also there. Now Milad, these writ petitions are listed for the first time. On the earlier date of that, these were not listed. Immediately we are ready to proceed with the case. Immediate because they are interconnected. Because the point in the writ petitions and the point in the writ appeal are one of the same. Learned single judge has taken 2 views. One is that without a judicial member, the bench cannot be constituted. Second point is that 180 days is concerned.
His submission probably submission of ASDI may be that there is no such requirement in law.
Yes.
Which has been ready to do provisions. Like Mr. ASCI, these respondents, counsel for respondents are willing to argue the matter.
But I am ready to argue.
And some in this bunch, some fresh petitions are listed. So, like completing the process, we will have to formally issue notice and all that. So,
in the writ petitions, we have filed our counters and pleadings are complete. Not so far, the writ petitions are there.
So, tell us an agreed date when we can hear this.
Lord, lordship may fix Lord any date, Lord, subject to your lordship's convenience, Lord, on Lord, 16th or 17th of October, Lord, if your lordship so pleases.
16th of October, what do you say? Yes, Mr. Srinivas.
Yes.
16th of October.
Lord, in the meanwhile, Lord, I would humbly pray, Lord, lordship may suspend the operation, Lord, of the order of the honorable single judge. Reason is, Lord, there is a direction that we have to release the properties, Lord, which are the subject matter of attachment. And this judgment is being cited, Lord, before other honorable courts in Hyderabad and also in other states, saying that an order which is passed by a single member is quorum non-juris. And therefore, Lord, on that ground, attachment orders which are passed properly are now, my lord, we are not able to give effect to it, and we are losing the security, my lord, which is there, which we are entitled to have. My lord.
No, we will say that the observations made shall be confined to the case of respondents only and shall have no bearing in other cases.
And in the meanwhile, let
But
them
we will clarify so that it is confined and we hear it on 16th.
Yes, madam. And the lordship may also, my lord, status quo will be maintained with regard to the attachments which are already made.
All right,
And
the status quo we maintain. Till 16th, Mr. Till 16th.
13(3), the writ petitions were allowed by the learned single judge. By following,
Status quo, whatever.
I didn't tell. Following Madras Bar Association judgment, where yes, without the judicial member, a tribunal cannot be constituted, nor that the judicial proceedings can be. Now, let my lords may kindly say, 21(9), my lords may kindly say, let my land fed say, they issued the notification for appointment of judicial member. 21(9). After 6 months after passing of the order by the learned single judge, now they open their eyes and issue the notification. What I am submitting, Millard, it is quietly covered by several judgments of the apex court.
That's why we have agreed to hear it on 16th. Right.
6 months, Millard, is it necessary, Millard, to last me put irritatement next week?
No, so all we are seeing is status quo. That doesn't harm you in any way. One. Learned ASGI submits. 1 minute. We are recording his submissions. This intra-court appeal arises from an order dated so and so, order dated After vacation then,
Yes, my lord.
that's a better idea.
Yes, my lord.
Or maybe,
After puja holidays, my lord.
yes. So it could be then, which date, Mr. You tell, both of you tell.
The first week of November, my lord.
First week of November, any Monday you prefer? 6th November?
6th of November, my lord.
List on 6th of November 23.
My lord, if your lordship so pleases, my lord, 7th of November, my lord.
All right, 7th of November 20. Yes.
So there are two issues.
Ah.
Page 93.
Ah.
It's also held that 180 days are concerned.
Yes, that the order has, yes, this only for the purpose of admission. This,
There are other issues.
then,
Two other issues also.
you say inter alia held, no. In addition, the learned single judges further held that the provisional order of attachment cannot continue beyond the period of 180 days.
Pending, my lord.
Item
Number 17 in the same batch, when IA is pending,
70?
dealing my case with the batch.
17.
Yeah. But IA is pending, my lord.
What
to
IA?
dealing my case with the batch.
What
do not-
IA is pending?
To dealing my case with the current batch.
No, there is no IA. This
IA
thing,
number 1 of 2023, my lord.
suspension, direction, early date. What is
There
the
is
same?
direction petition, my lord. Direction petition to dealing my case from the current batch.
Why?
Because they have not challenged the viruses of this act, my lord. And my main question is that the
Item 17.
my main
Yes.
challenge-
Who appears for respondents? What to say with regard to prayer for delinking?
But it can be delinked and had separately, but anyway, we are going to argue in before some other court.
All right. 17. Item 17. Party in person. That is the prayer. No, we are asking about prayer made in the petition.
But lordship may excuse my presence, but
Yes.
obliged.
Necessary to suspend. The same thing you have challenged. You have challenged the order passed by this thing.
Yeah.
Authority under PMLA Act.
Yes, my lord.
So why it should not be heard? You will be heard. There is not a question of virus, Mister. You have challenged the order of adjudicating
Yes, my
authority.
lord. But there are several other grounds apart from the
So you will be heard. That doesn't mean that you will not be heard. Nothing. Yes.
Thank you, lordship. Kindly.
Yes, please.
Directed that Eshwaram judgment has been clarified once the millet activities constitution validity of the statute is upheld. Whether subsequent millet the film can be questioned. The pattern of withdrawal millets. So that's like it's not a 60 launch. But now millet the judgments are given along with Eshwaram. Subsequent millet from his case. Apex court has considered Eshwaram and millet clarified that millet facts and circumstances of the case where other parties question the vice of the statute. Courts can entertain this. So then
Which context?
that you lordship pass an order blood pressure. Assist your lordship.
Validity upheld, it cannot be challenged like on new grounds. It can be done now. Acha, we will see when it is. All right. Thank you. Yes. Thank you. Yes. No, nothing. It goes same order. Don't write anything. Yes.
But in this case, senior counsel is suffering with fever. Last may kindly
Huh?
put up this matter on next Monday, my lord. Your lordship so pleases.
So what is this is for early hearing date?
Yes, for hearing, my lord, I have.
What is hearing?
The rule is under challenge, but amendment of the rules. Providing
So this is 22 petition, Mr. No hurry.
promotions are being taken.
No promotion. What is you tell us, Mr. What should there not be a scheme of priority? Like what 2005 appeals not, and these cases, so many of them have listed today for early hearing. Just because you want promotion before Deepavali, so you want
No, it's
petition to be decided, order to be passed.
A new rule has been.
Let IA1 of 2023 be listed for consideration in the month of January 24.
It's already interim order, my lord. Somebody filed implead petition, my lord. I need to file counter.
22.
I need to file counter, my lord.
Which
Implead
case?
petition is filed.
22.
22 and 24, my lord, go together.
22 and
24 go together.
you are petitioner.
I am petitioner.
For the petitioner, phrase fund is granted 2 weeks time to enable him to file. Yes. Mr. Your case will go before a special bench. Let this petition. This is SLP, right? 136. This order, if you don't like it. Yes.
Yesterday's Matt Miller, where the time was sought for.
Huh?
Yesterday's Matt Miller, where the time was sought for.
What happened, Mr. Pranav?
That's the interest to my colleague Milata. My name is not effective. The interest to my colleague.
My apologies, Your Lordship. I've got the instructions, Your Lordships, in this matter. Our case has been considered and rejected, Your Lordships, because as per the Honorable Apex Court judgment, Your Lordships.
Relax. 2 minutes, then speak. Give us, madam.
The sponsorship has to be by the very near relative, Your Lordships, for getting seat in NRI quota. Whereas the sponsor of the applicant was far relative of that is.
You file reply, madam, formally. Learned counsel for respondent submits that she shall file objections by
Right, please, man.
No, 25. 25, what happened? Done, all right, yes. Ah,
I have filed an
Ah.
affidavit.
what, Mr.?
I have filed an affidavit on behalf of the state, my lord.
Hmm.
Selection committee, my lord, took a decision in the matter. So far as the district consumer members and president are concerned, a notification has been issued on 4/9. In respect of state commission, my lord, we filed a review before the Honorable Supreme Court. My lord. Seeking clarity, the notification was issued prior to the orders passed by the Honorable Supreme Court, when the Honorable Supreme Court modified the appointment.
When have you filed review? What happened?
It is, I'm informed by the Senate Council.
Hey, madam, where is this? His counter.
Additional affidavit.
You keep counter with you.
Additional affidavit.
No, counter. Why do you keep it with you? This is needed, right? Yes. Yes.
My additional affidavits were not the.
Additional affidavit also. Yes. No, so first, what is your stand? You have filed a review petition.
Clarification petition before the Honorable Supreme Court, my lord. But the council is appearing in the Supreme Court and informed me, my lord, that mention has to be made before the Honorable Chief Justice of India. And he's heading a constitution bench, my lord. They are supposed to, I'm told, communicate through the email. But the date, my lord, probably will be granted for hearing the matter. Should be deferred for some time, my lord. All steps have been taken by the state. So far as the district consumer forums are concerned.
You are seeking review of the order in SLP 831
Yes, ma'am.
and 832. Yes, Mr.
I leave it on your lordship. A date may be fixed.
Leave it on. What can else can you do?
Taking efforts, my lord, by filing.
So fine, yes.
A lordship may fix a date so that.
Learned special counsel. We can't. Learned special counsel submits that the. Yes, counter not filing.
Not filed.
Why?
Taken up. Taken up.
No, you don't want to file counter.
Request time. Request time. Because the departmental proceedings are.
Learned counsel for respondent praise fund is granted for. This is not an achievement of not filing counter.
Oh, but proceedings are paid.
I didn't think.
Yes.
Right, please, your lord.
What permission?
I'm instructed to appear in IN number 2.
What is permission?
We filed the USR number counter, we filed an applications for opposing the withdrawal of the amount.
Lord, in the counter, with that appeal has become infructuous and they have liquidator admitted our claim to an extent of nearly 30 crores.
Huh?
Our claim is admitted by the liquidator, my lord, who is the respondent in this IA.
This IA you are seeking to withdraw the amount.
Withdrawal of the amount, my lord, that is already
Which is IA, madam?
IA number 2 of 2023.
Let my friend finish, sorry.
My lord, in the counter 11, they filed a counter, my lord. In the counter para 11, they admit that the appeal filed by the company corporate debtor has become infructuous in view of admission of my claim by the liquidator. However, they says if the appeal is infructuous, you cannot maintain this application in the appeal.
Huh.
Right? In the, what happened, my lord, the facts are like this, my lord.
Yeah, appeal, your appeal has become
No,
infructuous.
their appeal. My lord, there was an award in my favor, my lord. Against which they filed
Where is IA, madam?
IA 3, IA 2.
2. That's what you should this listed for that IA. Yes.
My lord, there was an award, arbitration award in my favor. Against which, my lord, they filed application under section 34. Their application was dismissed. Again, they have approached this honorable court by way of under section 37, by way of present appeal, COMCA 3 of 2019. Now, my lord, in the meanwhile, the CIRP initiated against the appellant company and now it is went into liquidation. My lord, liquidator.
So they have deposited the amount.
Yes, my lord. Meanwhile, in 2019, garnishes have deposited. Now,
This,
my lord,
you 65 lakhs and 89 lakhs.
yes, my
20.
lord. Yes, my lord. I am
Yes.
seeking withdrawal.
All right. What is
Now, my lord,
is it your case that appeal has been become infructuous?
Because liquidator was appointed, liquidator.
No. Appeal has become infructuous. Is it your?
I may just make this up. Sir, what happened, Lordship will say, when the COMA 3 of 2019 was filed, there is an order, specific order passed by the court in IA number 1 of 2019. In that, an order was made, 1 crore to be withdrawn by the petitioners herein, and remaining to be withdrawn by the respondent who is an appellant before the court. A review petition was filed, review was dismissed, so holding that I'm entitled to get take back 63 lakhs and not. Meanwhile, the Bank of Maharashtra has initiated section 7 IPC code before the NCLT. Ultimately, a resolution person was appointed and the matter went into liquidation so far as that is concerned. And the liquidator was appointed.
Mr. There is an award in his favor by the arbitrator. That award has been upheld in a petition under by adjudicating a petition under section 37. Under interim orders of the court, you have deposited this amount. Why he should not be allowed to withdraw? Because he will run away with the money.
No, there is a specific order. Lordship may look at IA number 1. Along the counter I filed, IA number 1 of 2019. There's an order passed by the court. IA 1 of 2019.
That he will not be permitted to withdraw the amount.
Yes, I am permitted to withdraw the amount. That is the order.
that
1 minute.
Yes, please.
This is the job of the council to create as much as confusion as possible.
Not confusion, clarity so far as the order is concerned, sir. Not creating any confusion. It's borne out by the record.
Yes.
Lordship may just look at the order, sir.
1-9.
That is order dated.
Which case?
That is COMCA 3 of 2019, IA number 1 of 2019. 10th April 2019 is the order.
No, order. Which dated order dated?
The order dated, Lordship will get it at 10th April 2019. 10th April 2019. Interim order.
I filed along with memo yesterday, my lord, that order.
Along the counter of
10th April 21.
19. 19, sir. 10th April 19.
10th April. Yes, got it.
Just Lordship may please look at 6th para in the order, second page. By the time Lordship will just 6th para, page number 2. By the time the parties came up with these appeals, the execution petition was filed, and it appears that the sum of which 2 crore 7,29,987 was deposited to a 24 bill, as of now being withdrawn by the first respondent herein. Therefore, even as per the award passed by the
Last line. 63 lakhs you have been permitted
Yes,
to
yes,
withdraw.
yes.
Ah.
That is last paragraph.
Last paragraph.
It is stated that the sum of which 1,63,58,000 is now lying to credit the court. This amount represents 25th bill. Question as to whether it is subject matter of arbitration is not becomes subject matter of dispute. Hence, we are of the view that that allowing the parties to take the portion of the same would ensure that the first respondent would not receive 50% of the upper amount. Without producing the contention of the parties, the application for stay is disposed of, recording the fact that the first respondent has already withdrawn 2,07,29,987 paid towards 24th bill. Otherwise, the first respondent to withdraw 1 crore out of the amount now lying with the court deposit. The balance 63,58,000 may be withdrawn by the petitioner. So this is the order becomes final.
Subject
And
to
the
outcome of the appeal.
just a minute, sir. Review petition was filed, dismissed. Stating that this is the order passed by the court. Now you want
Review when it was filed.
review was filed, just IA number, that is, Lordship will get it, IA number 2, sir, review petition. That is dated 5th September 2002, review orders.
Date?
Dated, sir, dated 5th September 2022.
5th September.
Yes, sir.
Yes.
This is the order, sir, review. May I read, sir?
Then that's enough. Review is rejected.
Yeah, that's what.
Fine.
Ultimately, it became final so far as that amount is concerned. Then once again,
63 lakhs.
yes.
63 lakhs is fine. What about 25 lakhs?
25 lakhs is making additional claim now in the application. 50%. The court says that 50%, it works out to 50%. That's a usual conventional order that's been passed by the court. If he wants to withdraw the amount which we are entitled to, that comes within the judicial liquidator.
Fine.
I'll submit, my lord.
How do you explain these orders?
Yes, my lord, that's what I'm
19-4 and
Yes, my lord.
10-4 and this
Yes, my
thing,
lord.
review dismissed.
10-4 order, my lord, it was passed.
What is the amount is there till earning interest? What is it that? Why do you want to this thing?
My lord, I'll submit one.
You have been permitted to withdraw 1 crore
Yes, my lord.
only. 1 crore and 63 lakhs by respond number 1.
Yes, my lord.
By appellant, and you have been permitted to withdraw 1 crore. Why another amount in contravention of the orders passed by division bench? A review has also been dismissed.
That's what I am.
Challenge, go to Supreme Court then.
Your lordship may kindly see. Now, subsequent events, my lord, what happened? He has filed the appeal challenging the award. Now, my lord, he went into liquidation, liquidator appointed, and liquidator invited claims under section 30 of the IBC Act. My lord, I filed my claim, which includes this awarded amount also. He admitted my claim for 30 crores. My lord, nothing will remain in the appeal to be adjudicated now. This appeal is filed against the award.
So we'll dismiss the appeal as infructuous.
Yes, my lord.
Correct.
He admits that appeal has become
The other matters also have to be dismissed. All the matters they go, sir. But we could, all the other matters, I think
That's what his submission is, that if it is infructuous, then you can't.
One thing, ultimately what will happen, lots is aware of the first 65 of the.
No, we are not applying our mind. You have said in para 11 of your counter appeal has been rendered.
That's the reason, because it comes up, because
that's the order which we are passing.
Once the liquidation process has commenced.
Para 11, right?
Yes, but they do not survive. Actually, lots of
Yes, then that's it, Mr. There's no, our time is precious.
No, that's fine. I do understand, sir. I do respect the right
Yes,
of the
yes.
court, because
Not
that's
be
fine.
presence, learned counsel for the appellant while inviting the attention of this court to averment remaining cases?
Remaining, I don't, I was inspected the remaining cases, my lord.
29, 30,
Yes, my lord. No,
31.
I'm not only three I was inspected to appear, that's the reason.
What about 29?
Yes, my lord. In the remaining, that formal application to implead liquidator is to be filed. Lordship may have it of 2 weeks, my lord. I'll file a application to implead the liquidator. Now, in respect of
So
the.
this appeal survives? These
No, nothing will survive. Nothing will survive. Nothing will survive, but the formal application to be
So
filed.
we will dismiss it, Mr. Why to keep it pending?
No,
To impede nothing.
no, our appeals, there are two, our appeals, my lord, they have.
Tell us one by one, Mr. Item 29, does it survive? Be fair, Mr. Don't like.
Yes, my lord.
Because we have not this thing, connected matters, we have not read it, don't
Yes, my lord.
this thing seek an adjournment.
Item
Be
20
fair to the court.
Item 29 does not survive, my lord.
Learned senior counsel for the petitioner submits that on account of efflux of time,
Thirty-two also does not survive, my lord.
does not survive, same order. Then 33,
33 also does not survive.
same order. 34,
Yes, but 34 and 35, that appeals filed by me,
ah,
my lord, for enhancement of the award. It is not survived. Since he has admitted my claim, that may be recorded and closed. Since the liquidator has admitted my claim, so my appeals, since he has already admitted liability by the corporate debtor.
there we will hear, not like this.
Yes, my lord. After 2
Let
weeks.
this item number 30, 34, 35 be listed after 2 weeks. Right.
Yes,
Yes. Next,
obliged.
36. What early hearing? Who has filed?
Respondent number 1 and 36.
Who has filed?
Not myself, I filed. I
What
filed
is
two
the-
applications, my lord, one to implead,
Heard on IA.
another on expedite.
Implead. Who?
Implead, my lord, the implead party petitioner, my lord, he is the agreement holder. In fact,
So this is pending since 2014. What were you doing in pleading and all this?
an agreement was executed on 3/1/22 last year. Then immediately we filed.
We will
the
see
application.
that. We will allow heard on IA 2 of 2022. Taking into account the fact that the appeal is pending before this court since 2014 IA is
If the
37 same order, 1st November. 1st November 23. Final hearing. Yes.
First November. Sorry, first November.
Yes. 1st November. Yes.
Meanwhile, let them die.
20, 38.
Hello. Lordship, in 37, direct them to serve copies to us, Lordship, respondent number. In 37, item number 37. They have not served copies to us.
How are you appearing then?
Respondent, Lordship, the matter is listed today, but in implead petition, they did not serve copies to us.
No, this is being heard finally, not interim application. Right? 1st November. 38.
My case, my lord, I beg to appear for the counsel, on behalf of the counsel for the petitioner, my lord.
That's all fine. What is early hearing?
Hearing, my lords, the petitioner is bound to retire in June of 2024, my lords, and pleadings in the matter are all complete. my lords. I kindly have it.
What happens if he retires? Nothing happens. With 2005 appeals we are hearing, Mr. Let IA be let IA 1 of 23 be listed for consideration in the month of January 24. By that time, hopefully, some backlog will be cleared, then perhaps we can.
Dismissed for non-prosecution.
What to do then? You don't appear.
But I was there on online, my lord. My matter was passed over in the morning. But it was
Passed over in the morning. Why?
But,
Because we did not have time.
no, my lord. Counsel for respondents sought a password. My lord, I was there online, my lord. Then, my lord, I thought, my lord, the matter would come up after lunch. But, my lord, it was called before lunch and.
That is the moment it is. We don't wait till lunch and all this.
Yes, my lord, I agree, my lord.
What is it?
Totally my mistake.
No, what is this thing?
Matter is, my lord, securitization.
Interim order obtained and surviving on interim order, right?
Not like, it is listed after a long time, my lord. I am ready with the merits also, my lord. It's a securitization matter, my lord, against DRAT.
Securitization, then appeal under section
My lord,
7.
it is against a DRAT order, my lord. It's against a DRAT order, my lord. DRAT passed an
You
order.
are into DRT and DRAT.
Yes, my lord. After
Both, there is no alternative remedy, right?
my lord, essay was, my lord,
No alternative remedy.
DRAT order, my lord, I am challenging here, my lord. Debt recovery applied tribunal
So
order.
say so, no alternative remedy. Why is it so difficult?
Yes.
We are asking you simple question.
Lord, petition is
You should
written-
say so that there is no alternative remedy.
But I didn't understand the question.
Oh,
Sorry.
but you understand, right?
Now I guess.
Satyavati Tandon, you understand Satyavati
Yes, my
Tandon.
lord, Satyavati Tandon.
In that context, we are asking you. So you should simply say no alternative remedy.
Yes.
For the reasons assigned in IA 1 of 2023. Next. Yes. 3.8 we have said that to list it in due course. Again it comes up. Magic.
I made a mention before.
Magic, right?
I made a mention.
Yes. What is it?
Milord, I beg to appear. I beg to appear on behalf of including petition.
No. Mr. 3.823 we have said that list in due course. How it has come today?
It was dated.
Court slip? Why? Who has taken court slip? This is abuse of process, Mr.
No, Milord, I have mentioned it, and at that time I was
Mentioned it? What? This is.
fifth page. I was told that it was.
No, Mr. See this pleadings. The petition has been admitted. There is an order directing to list in due course. How it has come up, and now you are disowning the responsibility. I don't know how it has come up. Then we will conduct an inquiry how it has come up and will proceed. If it is found that it is at your instance, it is listed.
I will not do such things, Milord.
You will not. No, very good, very good, very happy.
I made a mention before you, Milord. It has been listed.
No, this 1 minute. Give it to him. Who has given this?
He has mentioned.
It is. This is on a mention memo, Mister. By you.
Me, Milord.
Then you are saying that I don't know how it is listed.
I made a mention, Milord. On that day, I was informed it was on 6%.
No, who has filed this? Then to say so that yes, sir, I had this thing, I had moved the mention memo. You are saying I don't know.
No. I have made a mention, Milord.
This is on a mention memo listed. We have admitted the petition on 3.823 and have directed this listing in due course. What is now early hearing? What is?
I have made a.
Who you are petitioner?
My petitioners are from number impleading petitioners. I'm representing.
No, not impleading petitioner, Mister.
Okay.
This is who appears for petitioner.
Madam, I'm representing Rahul Reddy, madam. We are counsel for petitioner.
Says somebody has filed an implead petition in your case.
I have filed.
Why?
Because we are the affected parties by the.
How?
We are the eligible candidates for the promotion plan. Which was under the.
This has been admitted. It will be heard. What is there to implead?
The majority of.
I make one submission. While admitting and posting it to be listed in the usual course,
when he mentioned that my implead petition is pending, your lordships have said that will be decided at the time of hearing. Your lordships,
We didn't say that, unfortunately. That's why he got it.
orally your lordships have observed.
That's no, we relied on that all counsels appearing or officers of the court. We should have been very specific. We didn't know that he will take advantage of that
No, but the
situation.
proceeding sheet also reads that pending IA shall be considered at the time of hearing of the petition.
Then all this thing pending IS, which order sheet?
Order sheet dated 13th September.
In view of order dated 13/9/2023, directing that pending interlocutory application shall be considered at the time of final hearing. No orders are required to be passed on IA 1 of 23, 2 of 23, 2 of 23, 2 of 22 and 1 of 22 at this point of time. Yes, what is early hearing? Who has filed? Since the impleading petitioner has filed an IA for early hearing which is yet to be allowed, let the application itself be listed in due course. Yes.
I'm obliged.
Next. What is this?
May please.
Who has filed?
May please your lordship, my lord. This is
You have filed an application for early hearing.
not early hearing, my lord. I filed an application, my lord, for implead application I filed because I am an affected.
You want to file objections? Fine, do so. Learn it. No, objections to implead petition you don't want.
And one more thing also.
No objection.
And also.
Fine.
One more.
Third on IA number 1 minute, madam. Implead petition means he has no objection and then the cost title has to be this thing. Third on IA 3 of 2023 and IA number 11 of 2020, 11 of 23, 2030. You have said I have no objection. You carry out. We will consider.
I filed in IA 10.
IA 10 will be considered after 1 week.
It's an anti-date. IA 2 not filing implead. I filed that IA.
So it will be, everything cannot be heard, mister, because you want it to be heard. Please tell me, please tell us, what is the sin committed by a litigant who has approached this court in 2005 and is waiting? What is the sin? No sin. We don't want to argue. Yes, go ahead. No, after 1 week. 1 week. It will come up. This order again is open to challenge if it's not to your liking. Yes. Next.
Your lordship may post for hearing that my IA may be allowed.
No. You have said that you don't have any objection to implement it. So you carry out the amendment first.
They will carry out.
Whatever, whosoever. I don't know. It's your petition. If according to rules here, they will carry out. They will carry out.
I only request you.
No request.
Here, they are finally.
We will decide a date when your application comes up for hearing. Today is we have allowed the impleadment. Yes. We have allowed the impleadment today. We will not. We have said that IA will be considered remaining IAs after 1 week. This is the order. Yes.
My IA may be posted.
No. After 1 week we have said. Yes. Next.
without date from the office not posting.
No. It will be, you know how to get the cases listed. You come out with 5 court slips. We have seen.
Again, I can't make it.
Ask your junior colleague to do it. It's not at your age, you should not do everything. Ask him who's assisting you to do something. He will learn. It's your duty to bring him up as a good counsel. We are conscious about that fact. That's why, please, next. No. Yes, counter.
I'm okay, but first and second. I request you not to grant 2 weeks time.
Learned counsel for respondents, praise for.
I filed 6 months back. But last time you take, after that case is admitted. The case is.
What you are opposing? You don't want him to file the counter. Time should not be granted.
I am seeking interim order. How many times you are kindly see? The state allowing me that one officer.
There's no need to shout.
No, not shout. Please, you are
Switch off.
Sir.
All right. Yes. You are arguing the case on interim relief, right? Yes. That we will decide. So it is item 42. Yes. What direction? What direction? Post the petitioner in a place of your choice. Right. Place by accommodating them as superintendent, so and so. Yes. What basis this direction can be issued? This is only for interim relief, Mr. Don't argue for. We will not give you half an hour. Conclude in 5 minutes. Petitioner is.
And it has been promoted as that's not a of the after promotion, if you obligate on the part of state, and then complete, and that issue posting orders. These are the serial number 3. It's the most century. The entire state is not the
Senior most. So what he is not being given posting?
What happened? Is conduct mostly. Okay. You participated mostly.
For posting. So they are not doing it.
From those there they wanted.
We have got you understood. Yes. Mr. Has he been promoted to the post of additional director?
27/2021, he has been
Promoted. Then he has to be given posting. 1 minute. He has to be given posting as such, being he has been promoted as additional director.
Yes, been done.
Done?
Yes.
When?
Page 79. Superintendent, Government General Hospital, 140.
Superintendent?
He has been given. This is an order issued in the year 2021.
Which page?
Page 79.
79. Yes.
GORT number 698 dated 7/12/2021. Lord, in the table, TSHC number 3.
Yes.
Right side, Lord, Superintendent, Government General Hospital.
Yes, Mr. Now, what is your grievance? What interim relief? You have already been posted and serving.
Posting should be based on the Milad counseling. As third person, they conducted counseling. I can choose Milad counseling.
So your submission is without counseling. So therefore, you should be posted at Government General Hospital, Vanapanthi. This is the prayer.
It's supposed to be upper fee.
Ah,
Subject is not there. They are not slating my services.
all right. Yes. All right. Fine.
Page number 89. Page number 89.
That's what we are understood, right? 89. So their services, your services are not being utilized, but you are being paid salary, right? Happy? Yes.
89.
Yes.
Government issued orders following procedure in the appointment for civil and also government of all the
Yes. So this order has to be quashed, right, to get you the relief 7/12/21 by way of an ad interim order. Then, if this order is quashed, then only you will be entitled to posting somewhere else. All right. Understood. Anything else?
What happened?
Will be subject to that we will record. They have to find out. Yes. All right. Yes.
Four is all clear.
All right.
Second candidate. Government posted email charge director medical education. Based on recommendation, that persons like not me, both respondents have two the likes. Posting not places not city. And not I should have given not charge director. Thinking that not right the post. He will not influence the government to post not parliamentary. Where will not pedagogical subject is not well. In this day, only two not themselves. Posting will not pedagogical subject. One is both respondent, second is mine. Second, both respondent for the sake of paper, he is going to post of principal, not in medical college. But he is doing administrative work as director of medical education from 2017, but doing so much better. That go on to should exceed that they are not clear about all this. Now we are this is the case. Now this case is noticed for admission of the order. No count is paid. In Hyderabad, all the restaurant. After two lawsuits were admitted and issue notice, no notice, even then they did not find out that even for individual. That is not identity, deprived, but my rights, not anything. And now,
Learned senior. That's it. Learned.
and now, the respondent also will not appear, submitted on one time. Post graduate level. Small.
Learned. It will be the young man that we are concerned about his future. No, not difficult. Not difficult. Not difficult. We grant. No. We are granting every mentioning, Mister. You should be here in the morning. You know, all your mentioning has been granted. We don't. This thing. You don't come. This young man is with you. The person. Let him. You send him. We will deal with him. No, don't come. We don't want to trouble you. No, nothing. No, there's no first, second vote. This, let him come. We want youngsters to argue. Let it, you send him. Mention. We'll do. Yes.
May I please?
Yes.
Lord, application is filed, my lord, seeking appointment of arbitrator. My lord, notices were served, my lord, no counter is filed. And your lordship may see, my lord, another
Counter is filed.
No. I seek time, my lord, 2 weeks time.
No, nothing. No weeks. 2013 matter, Mister. This is a joke. Supreme Court has deprecated. If the arbitration, I was shocked to know these matters have been listed. We found out that there some arbitration matters are pending. What is this? It's not like it's worse than a civil suit. In civil suit, by now, at least evidence would have been, it would have been at the evidence of at the stage of evidence. We are sorry. Nothing.
Lord, in fact,
No.
it is covered by constitutional bench of the Milord Supreme Court. The agreement is not, Milord, properly stamped.
That's it. Then it goes, Mister. You know that.
No, my lord, what happens?
No, nothing happens.
CRP 44
Madam, judgment, Constitution bench judgment. 2023, volume 7.
My lord, sir, kindly.
1 minute. We are not doing anything, Mister. You are not assisting us. We are trying to find out.
No,
because we have to write an order, right? We do the homework for you, right? No, we do the homework for you. And still, if you have guts to argue contrary to Constitution bench, God alone can help you. See, this agreement is not properly stamped.
My lord, that is how CRP 4181 of 2014 before your lordship, item number 44 is before your lordship.
First, item number 44, give
before your lordship.
Give item 44.
My lord, what happened in this case, my lord? I filed an application.
1 minute. 1 minute, please.
43, 44, 45 are one and the same, arising out of the same.
43, no. 43, 44, 45 are not same. 43 is arbitration application, 44 is CRP, 45 is CMA. Not same.
Section 9 application CMA, my lord, as against section 9 application. My lord, this
application has been rejected on the ground that the agreement is insufficiently stamped.
Yes. Now, your lordship,
what is wrong?
Yes. My lord, I will take your lordship to agreement at page in CRP, my lord.
No, Mister. First, you should tell us what is your contention that it is properly stamped.
Yes,
it is properly stamped. That is so. They say so.
Yes, it is properly
taking doesn't mean.
Sorry.
So then
it is a properly stamped.
Mister. Fact is that it should be properly stamped is a law conclusively laid down by Constitution bench of Supreme Court, which is binding. If you don't feel like it is still binding, right, on you, you may not feel.
I'm not.
But so this proposition that the law laid down by Supreme Court that an arbitration agreement has to be properly stamped, that binds everyone. Now you tell us how it is, what is the requisite stamp duty, what is the document, what is the requisite stamp duty, how much it has been paid. Simple.
Yes. My lord, under Article 6C, my lord.
No. What is the agreement?
Agreement is at page 33. Agreement, my lord, the applicant is a construction worker, engineer. He entered with a contract, my lord, with the respondent.
33 is no 33. There is no agreement at 33. Agreement is page 27. Agreement for construction of building.
Yes.
Yes.
My lord, may I read? This agreement made and executed on so and so. Mohammed Shafiq is the owner of the property, my lord, and I am respondent, my lord, Mrs. MR Constructions is the person. Whereas the engineers contractors is desirous of carrying out civil works for the proposed residential building at survey number so and so, whereas engineers contractors has approached the owner, expressed his willingness to carry out construction work as desired by the owner. Whereas the engineers contractors has assured the owner that they have necessary experience, technical skill, manpower, material infrastructure to carry out and complete the works as desired by the owner. Whereas the owner accepted the experience of the civil works of the engineer contractors and decided to entrust the construction works to Mr. MR Constructions, who shall be engineers or contractors for the above said residential building of having ground floor plus 3, but constructions D plus 2 floors, only total 9 flats plus 1 watchman room plus 1 shop, whereas the approximate slab area for the execution shall be as per plans. Whereas the engineer contractors has agreed to complete the above said construction within 365 days from the date of contract agreement as per drawing, as per the terms and conditions and specifications mentioned below, Annexes 2 and 3. A copy of the agreement kept at site and may be referred to whenever necessary. Terms and conditions for construction of building. The contractor work will be started within 8 days from the execution of agreement form. The construction of building will be completed within 365 days, depending on the site condition and availability of material and manpower. If any delay is caused only due to unforeseen reasons, such as unfavorable climatic conditions, strikes and bunds, etc., all the required tools and plants, machinery and employment and building walls, baskets, spades and crowbars, scaffolding with rope shall be arranged by the engineers contractors. Well, these are all the terms and conditions for raising the building, by the engineers. No interest is there in the entire reading of the agreement. The owner has he took only contract, my lord, for constructing the building in the land of the owner.
So it is under 6B of the Stamp Act.
According to my lord, the code below, it is 6B under the contract. Stamp Act section
6B.
Schedule 1
6B.
6B of the. My contention is, my lord, it will be under 6C because it's only a civil works contract. It's not a development agreement. There is no interest is given to me. I am not.
Agreement relating to construction of a house or building, including a multi-house or building, so and so.
Yes. Then the subsequent clause which is there, that is, your lordship will see.
This is an agreement relating to construction of a building, right?
Construction of a building by an engineer, not for development, not for sale. He has not taken anything for sale of that building.
No, it doesn't say for sale.
Last paragraph, your lordship will see.
No, it is by an engineer or by a chartered accountant, by a doctor. That doesn't determine.
Lordship, right, my lord, it doesn't say so.
So it doesn't say also that if it is only for by a doctor and for sale by an engineer and not for sale, therefore 6B will not apply. It's not like this. The decisive words are relating to construction of a house or building. This thing, admittedly, Mr. One thing we must understand. If it falls under section 6B, it is not your case that it is stamped as per 6B. Your case is it is under 6A. 6A.
6C.
6C. So 100 rupees.
100.
All.
Now, my lords, make
So how it is 6C?
My lords will see the 6B reads, my lord. May I read 6B, my lord?
In relating to?
If relating to construction of a house or building, including a multi-unit house or building or unit of apartment, flat, portion of a multi-storied building or for development, sale of any other immovable property. This sale of any other immovable property was considered by our division bench and it was held, my lord.
Or for. It's not and. Please understand or.
Or sale of any
or
other.
For development, sale. This is an.
Development, or sale of any other property.
Not and.
Yes.
Both the conditions should not coexist.
Yes. Now, yes. Now, my lord, what happened in this case, my lord? The 6B, there is a adjustment, my lord, given in what say Article 47. Lordship, may kindly see Article 47A of Schedule 1A. My lord, this Article 47A says, suppose I pay any stamp duty under section Article 6B, then it will be adjusted. If
The court is not concerned with this thing. Court is only required to find out whether it is properly stamped.
Yes, only to
Under
that extent.
section 33 of the Stamp Act, any document not properly stamped has to be impounded. Simple.
No,
I mean, an adjustment, what you find out with adjustment, what is with him.
No, the proviso, my lord, to explanation to Article 47 says, provided that where subsequently a sale deed is executed in pursuance of an agreement of sale as aforesaid or in pursuance of an agreement referred to in Class B of Article 6, the stamp duty, if any, already paid or recovered on the agreement of sale, the adjusted towards the total duty leviable on the sale deed. My lord, this I will never get. I am only a contractor. I only executed the work. I have no interest or right in the entire construction. I must only get the value for the services which I have provided to him. Therefore, it is neither agreement of sale nor agreement of any right in the property.
Is it not an agreement relating to construction of a house?
I am only a mason.
That's correct. Then also, the value is above 100 rupees. No, it doesn't say, see, the agreement or memorandum of agreement provide in relation to construction of a house or building, including a multi-storied or building or unit of apartment, flat portion, so and so, or element of sale. No, or. So if an agreement is in relation to construction of a house or building, or for development of sale of any other immovable property. This it is the agreement may be for development sale of immovable property. The agreement is not getting any to sell. What I'm saying is that even if it's an agreement relating to construction of a house or building, including so and so buildings, this is. So we have to read up together. Or is this agreement may be to unit of apartment, flat, portion of multi-story building, then for development sale of so and so. It's not and. We can't read independently. We can't read the and. All right, we have understood your submission.
My lord,
Fine.
this judgment is, my lord, underwent an interpretation by our High Court and Division Bench.
Yes. That's important. So it has been read what, how, and.
And your lordship will see, my lord.
And. Yes.
My lord, because otherwise, my lord, an engineer cannot have any right over the property and adjustment will not be able to do under 47.
No, the engineer means it's not that we are against engineers or something like this. So the only thing is whether he can invoke the arbitration. I mean, if he doesn't invoke, then he has the remedy to file a civil suit. Yes.
To articles speak, I'll take your lordship, my lord, to direct me to paragraph 19.
19.
Yes. Article 6B is very clear in its expression.
1 minute.
I'm sorry.
This is different. The question was whether it includes agricultural land also.
That was the question, my lord. Thereafter, my lord, at para 16, my lord, para 19, my lords may kindly.
We are seeing para 19 only.
Then, my lord, on the right hand side column, my lord, a careful reading of.
This is amended. This agreement does not contain agricultural land. Does not cover agricultural land. This is the ratio.
That was the ratio, my lord, while interpreting that the adjustive generis clause need not be looked into, specified words only has to be looked into, and what follows is sale of any other immovable property My lord, only for the purpose of construction, my lord, a construction contract, it's a civil works contract given to the contractor, and it is not a development agreement. It is not a development agreement that he has got any right in the property.
No,
And there, why
we see, Mr. We are dealing with the expressions provided for by the legislature. It does not say development agreement. It says agreement or memorandum of an agreement in relation to construction of a house or building, including a multi-unit house or a building, or unit of apartment flat, portion of multi-storied so and so, or for development and sale, an agreement or memorandum of an agreement for development sale of any other immovable property. So this is it is first part is agreement in relation to construction of house, agreement in relation to development and sale of any other immovable property. This is how it is in two parts. So this is, I mean, we don't think that it helps you in any way, like 2004 division bench.
My lord, may I trouble your lordship may kindly bear with me for a moment, my lord. Article 47A.
This adjustment, we are not concerned. We are trying to understand the nature of document, Mr.
Yes.
If you have anything to say in respect of interpretation of this article, then it's all right. This adjustment appropriate to you, file against him, do whatever.
No, I am
that stamp duty, I have to recover this much of amount. I have constructed his house. He is not making payment of amount. Do whatever.
My humble submission, my lord.
This is what it says. It's this thing. See, it is in two parts. Simple, right? Agreement on construction of building, house, so and so, so unit, apartment, so and so. Number two is for development sale, an agreement or memorandum of agreement for development and sale of any other immovable property. This is what it is in respect of other immovable property, which is not covered under this building, etc., units, house. That's why separate parts. Nothing. Yes. Thank you.
My lord,
You have done your best.
My lord, and one subject. Your lordship may kindly go to Article 47A and 47A of stamp.
So you read, what is it?
47A of Article.
That is apportionment, right?
No, my lord. What happens, my lord? Why say 6B is carried there, my lord? Say Article 6B is carried there, where there is an adjustment. Lordship may kindly say.
Adjustment by the court, right?
Not by the court.
So like, so court will adjust the pay from its salary to amount to you because you are an engineer. Adjustment. What is, you tell Mr. Instead of repeatedly tell us so that we feel interested. From you are repeatedly telling adjustment, that is irrelevant. Because
what happens in the development agreement is the developer suppose constructs the property and sells it. My lord.
Your argument is like this thing. A petitioner is a poor person. We are telling you what is your argument. We are telling you what you are trying to argue. Petitioner is a poor person. He is an engineer. He constructed the house for respondent. He has not been paid the amount. Wherefrom he is not get. He has no interest and title in the property. He is not a development agreement. He wants his money back. Therefore, please appoint an arbitrator, even if it is not duly stamped. Ignore it. Interpret it in such a way so that 100 rupees is enough, because wherefrom engineer will get money. This is the substance. Whatever you are saying.
Why it will not fall under Article 6B is, my humble submission is Article 6B.
Now you please conclude now. Yes, which article?
47A.
Responsia 1 sale.
Yes. 47 is sale as defined in section 54 of TP Act, Transfer of Property Act 1882. My lord, here your lordship will see the explanation. An agreement to sell followed by evidencing delivery of possession of the property agreed to be sold shall be chargeable as a sale under this article, provided that where subsequently a sale deed is executed in pursuance of an agreement of sale, as aforesaid in pursuance of an agreement referred to in class B of Article 6, the stamp duty, if any, already paid or recovered on the agreement of sale, be adjusted towards the total duty leviable on the sale deed. Therefore, if suppose that I have got a right, my lord, under the contract, and that if I sell the property, that adjustment will be given to me, that benefit will be given to me.
So
that is my humble submission, my lord. Therefore, it is not a contract. Contract which falls under class 6B, Article 6B, is falls under 6C.
all right.
No, my lord. Even if suppose assuming for the moment, my lord, that your lordships comes to conclusion that it requires stamp duty, then I am liable to. I am entitled. I may be permitted to pay stamp duty and proceed with the case.
So that's what we are saying. You should have said.
So lordship comes to conclusion.
Conclusion comes to conclusion. So you this thing will this thing dispose it of, that it has to be paid. Well, you want an order on merits, right?
Yes.
That's it. So what if any? You are not giving any concession to us.
If I
All right.
comes
Yes.
to conclusion with regard to payment of stamp duty, that it is liable to be paid under class 6B, and confirming the
No,
order.
we will see, Mr. Your petitions will be disposed of with the liberty, as and when you pay the stamp duty. Thereafter, you can revive these petitions under section 9 and 11. Right, because that constitution bench decision. Yes. Mark the presence. Yes. Nothing, no adjournment. Ah, ah.
47. Here it was allowed to respond before a review.
Nobody has preferred a review, right? No, nobody is there. Allowed. CRP has been allowed.
Preferred a SFP or SFP switch. Subsequent to that, he files a review for this.
And nobody is there. So what is this this thing? Just CRP. Yes. When it has been allowed.
On 5/2018.
Where is it, madam?
47.
47. So we will first deal with 47. None for the petitioner. None for the petitioner in IA 1 of 2019. So and so for respondent. It appears that the petitioner is not interested in prosecuting IA number 1 of 2019. The same is therefore dismissed for want of prosecution. Now what?
46. It's a big what the article. Court said there has been way for bond.
No, this is arbitration application, right? So what? You want appointment of an arbiter?
Doesn't survive now. In view of the orders passed the CRP, CRP is probably put there. Then the agreement.
Like, what did it say? See that CRP. CRP, what was said?
That the agreement has been waived in view of subsequent agreement entered between the parties.
Yes, you're right. In view of order dated 2/5/2018, passed in CRP number 6384/2017, nothing survives for adjudication in this arbitration application. The same is nothing survives for adjudication in this petition. No, in delete by order dated 2/5/2018, passed in CRP number 6384/2017. The see, the pending says 13, 18. We should not. Yes. Yes. You have appeared in the examination, right?
Yes, sir.
So let your results be declared. What is there?
They have to file the forms.
No. They may not file it, but this thing, there is an interim direction.
Yes, sir.
So let your results be declared. What is that?
Yes.
Declaration of result will be subject to result of the petition. Right? Mark the presence of bench of this court by an order dated 12/7/20. now.
In all the
Give it
five
to Registrar Judicial. Registrar Judicial, give it the order. Yes.
in all the five matters, my lord, counters are submitted. It is pending for approval. In all the five matters, counters are submitted, my lord. It is pending for approval, my lord.
We don't know. We have given you, don't make it 2 weeks, you do it, mister. Instead of 3 weeks, 2 weeks. 2 weeks time to file counter. Failing which appropriate order shall be. Yes.
This matter, my lord, the report is ready, my lord. We need to file. On behalf of DHMC, my lord, we need to file a report, my lord. Lordship may have it next week, my lord.
No, this is 2005 matter.
The latest report
You
is ready.
keep the report with you, we will pass orders. What, Mr. This what, 18 years? Yes.
My lord, on 15th September, my lord, in fact, I had given a note, my lord, saying that on 15th September, they sought time, my lord, saying that today they will be filing the report. This is drinking water scarcity, my lord, because after 2007 again, it has not been listed. But I have given a note, my lord, of the issues which require, my lord, their attention and their report.
Yes.
Lorships have passed the orders also.
Yes. Yes, status report.
But in this matter, I'm going for GHMC, my lord, the officers have given us notes, my lord, where I suggested to get up.
No, let them appear in person if they are not right. If they are busy moving, roaming around.
It's not a case of busy, my lord. They approved the short report, which we
This is
sent to-
pending, Mr. This is a public interest litigation pending since 2005.
And I sent for approval for the Advocate General because in this matter relating to state, only for Monday, my lord, we are.
Learned counsel for respondents pray for and are granted a week's time to enable them to file status report in the light of
The fifth respondent, Lord.
Lord, on this matter, my lord, the last occasion, your lordship directed to inform the steps taken, my lord. We already, my lord, removed some of the extent of encroachments, and also, my lord, this lake is consisting of patta lands. We were communicated with the owners, and we asked them to take TDRs, and so that, my lord, the lake can be extended, sir. And thereafter, the fencing work can be taken up. The certain lands are, patta lands are there, my lord. The GHMC is taking steps to, my lord, create a cycling track as well as.
Mr. You need to tell us what is it about. This is final hearing matter.
No, it's on the last occasion, your lordship has directed us to give a report.
No, is it not final hearing?
It's a already
No. It is listed under what caption?
it is listed for final hearing, but on the last occasion, your lordship has.
No. So, do you expect that this court to read also final hearing and you will argue whatever you feel like and the court should understand? Then sit down. If you are not here to assist the court, then sit down.
May I suggest?
We will see the order sheet.
But matter pertains to protection of a particular one single lake, my lord.
1 minute.
In the year 2020.
1 minute.
A large bill.
He is asking us to help ourselves, right? He has the liberty to say whatever he feels like without telling us the facts. 1 minute. Encroachment of from Ramnathpura. So report.
Lord,
there is an order. You are must not be aware about the order.
Lord, there is a subsequently, my lord, about the larger interest for 3,553 lakes.
First read it. This is very strange that if you have appeared on the last date of hearing, we have passed an order running into 3-4 pages. You don't know that. Just subsequently and formally and this thing. Anything like say anything and get away with it, right? This doesn't mean that being on this side.
My submission, Lord.
You see the order first.
This is in respect of one particular lake. And
we are not, we are concerned with, in case you are unable to comply, then whom you represent, he will remain present. Let's, one lake, give it. You are representing whom, mister?
The fifth respondent.
Then let him remain present then.
But this is given to the THHC, Lord.
Nothing.
I'm just here to assist the court, Lord. I'm saying that.
No. Assist means district collector is a party. We will order his appearance.
Direction is to the
where is the status
THHC,
report?
Lord.
That is, I passed on.
Where is the status report?
I passed on this instructions, Lord, the status report for preparing status report. Lord, we addressed the letters to the concerned authorities. And
who is the concerned authority?
Lord, the HMDA as well as the EE, Lord, to acquire the land because there are certain patta lands are there in the said lake.
You are appearing for whom?
GHMC, Lord. Initially, it was in a Uppal municipality, Lord. Thereafter, it is
GHMC is not a party in this petition.
After that, Lord,
so you will appear for somebody who is not there.
That the municipality was merged into GHMC. Now, in the 2005, it was in Uppal municipality.
Who heads GHMC? Who heads?
The commissioner.
So let him remain present.
Only one humble request, Lord. That is what I placed
nothing, mister.
They
are busy touring out United States and everybody.
I may say one thing, Lord.
No, we need to give you some shock treatment.
No, Lord.
He is saying that this is one lake. So that means don't take any action. This is his submission. One lake. You are saying that this thing, there are orders passed by this court and the report has to be filed.
That is what, Lord,
that you have not done.
Instructions.
You don't tell the facts. You don't.
I passed the instructions, Lord. Your Lordship.
What is this instruction?
That is what.
This is of no use to us.
No, Lord, what the steps we have taken, because it is on the last occasion, Your Lordship.
You are required to file it, mister. This is the way of filing when the case is called. Just pass on the written instructions.
I'm sorry.
It is not. Is it signed by anybody? Who owns the responsibility of taking this, whatever has been stated? It is not even signed by anyone.
That I directed them to create
the
bundle because there is a 3 departments are to be involved So we
No, no, whatever, let the 15 departments be involved. That doesn't mean that you will not comply with the order.
We are ready to
Because
comply with
3 departments are, no, you have no option, mister. Challenge this order in Supreme Court otherwise.
Only for one.
No, mister.
I will say one thing.
You don't, mister, in matters pertaining to public interest, don't defend incompetent and inefficient officers. You are not paid for defending. You are appear, always remember, your client has not purchased you by paying instructions to you. You appear in your foremost capacity as an officer of this court, and we give you that respect and regard. But you compromise your position all the time, stooping down to such a low level for your clients. Have we purchased you? Inefficient people have purchased you. What is this? This is a matter. The approach should be different. You approach everything like it's a adversarial litigation.
Only I would like to bring to you.
No, whether the tank and water bodies have to be preserved for you. Your officers want to, by bribing themselves, want to construct a colony on that water body.
That is what I would like to bring to only one thing to your lordship.
No, mister.
Not saying that
we have explanation.
The moment
Commissioner GHMC will appear.
only one thing.
Will we issue bailable warrant or will he appear?
I may say one thing.
No, he will appear. These are the two options.
He will appear, my lord. Before that, my lord, I will say
No, when he will appear?
only one thing, my lord.
Write down. Mark the presence. What will happen? He will remove you from the panel. Nothing happens. You will survive. Don't beg him.
Only that thing.
You tell him that the court means we have passed an order. We are not sitting here to this thing further convince you that this thing. If he doesn't appear, he will face music. Why should you bother? You are not given any explanation why status report has not been filed. You are passing on this to written instructions. Written instructions can be given to us. Who has signed it? We have not said, we could have said 2 more paragraphs.
I'm sorry.
Don't do it. This is court hall 1. Its dignity has to be maintained at all times. I will not permit it to be this thing. Not because I am occupying, but this court hall will remain forever. You cannot do like this. But who is giving written instructions to whom? You are giving. Who has found it? Who takes this responsibility? Did we say that give written instructions? You want us to record everything?
I'm sorry, sir.
You don't do anything, and unproductive things, you want the time of the court should be wasted, right? This is the strategy. So that other case may not be taken up which can be heard. You want this to go until 4:30.
I'm sorry, Mills.
Don't waste. Always remember you are an officer of the court. And all of us are under an obligation to maintain the dignity of this court. Always remember. Don't beg for them. They will face the action for their consequences. We will call Deputy Commissioner also. He says 1 lakh. He says that it's only 1 lakh.
There's larger matters pending before this court, my lord.
No. So therefore, other lakes are pending. Therefore, don't do anything for this lake also. Tag this matter with bunch and adjourn. This is the submission. We understand. Yes.
Bless.
Yes. Huh? Huh?
The consular record is
And you are what? Out of record. Counsel for out of record. Counsel on record and you are out of record. What? Who are you?
I've just been asked to
Nothing.
adjournment.
No adjournment. You tell your senior that court hall 1 does not grant adjournment.
There's a connected matter which has been
It will be decided.
Which has been
That connected matter will also be decided. Don't worry.
That's not listed today, my lords. My lords may have it tomorrow.
Nothing.
Yes.
Yes, please. Mr. What is the case about?
In fact,
he doesn't know anything. Sit down, Mr. Sit down. The prayer for adjournment is not being granted.
Manoj, I'll submit the facts of the case, Manoj, if my lord permits.
Of course.
I am.
You are most welcome to argue, but you are not. We thought that you will n number of times you will repeat it, be adjourned. We want to make it clear. Don't this thing. Old cases, no adjournment. It is not listed for adjournment.
The writ appeal has been filed challenging the order of single judge, whereby the single judge dismissed the writ petition filed by me challenging the resumption proceedings issued in respect of the land, Manoj. Initially, the 12 writ petitioners, 12 in number, were allotted a total. Manoj will kindly have a look at page number 3, page number 5, Manoj. That is my writ petition. That is my writ petition. Paragraph number 3 of the writ petition is the facts of the case. A total extent of 55 acres of land. A total extent of 55 acres of land was declared as a surplus, agricultural surplus land, and this was allotted to landless farmers. Total of 39 farmers were allotted this land, each of an extent of 1 acre 44 guntas each. This land was allotted in the year 1980. Malords will have that averment at paragraph number 3 of the writ petition. This was allotted in the year 1980. Suddenly in the year 2004, the respondent number 2, who is the revenue divisional officer, issues the impugn notices cancelling the allotment on the ground that the land has not been used for cultivation, and this land is later on allotted to the respondent number 5. Challenging this, we filed a writ petition in the year 2006 stating that no notices have been issued to us. The order which has been passed by the revenue divisional officer has not been communicated to us. This writ petition came up for admission before the learned single judge of this honorable court, and the learned single judge of this honorable court opined that there is delay and laches in filing the writ petition. Therefore, this writ petition could not deserves to be dismissed. My specific ground in the writ petition is that we were never served a copy of the notices. No show cause notices have been issued. The procedure under the act has not been followed, and therefore the resumption which has been done in this particular case is bad in law. the delay which has been occurred in filing of the writ petition, which is, may I only submit, which is 1 year, 1.5 years, my lord. In filing the writ petition, the delay which has been caused is only 1.5 years, which in my respective submission is not a great amount of time. And considering the fact that they are agricultural.
What according to you is
Malad,
great amount of
well, that my lords will eventually decide. My respective.
Don't be nervous. Don't be. You are arguing well. Don't be. Yes, yes.
My respectful submission is this: these are all poor agriculturalists landless farmers who have been allotted 1.5 acre each. They were cultivating the lands. Their names have been reflecting in the Pahanis.
Mr. Finding is show cause notices have been served on it.
Yes, my lord.
You have submitted explanation also.
I haven't submitted explanation, my lord. It is
says the single judge has recorded a finding. I don't know what he has said. You should perhaps tell that how this is. You should tell us what single judge has held. You said only delay and latches and you had no notice. Yes. When we have seen in the order, he says the show cause notice has been served on petitioner. You have
come to the
explanation. You have submitted an explanation. Then, despite notice, you did not adduce evidence. And thereafter, the order has been passed.
May I, with great respect, say this, Manoj? When the counter affidavit has been filed by the department, we had asked for a chance to file a reply affidavit to reply to each of the contentions which have been raised by the department in the counter affidavit. That opportunity was not granted to us, and the writ petition came to be decided on the same day. Therefore, a chance to answer any of the averments placed on record by the respondents in the writ petition was never given to us. With great respect, that is how these findings have been recorded in this thing. So, my respectful submission before the
So therefore, no notice was given, no opportunity. You did not know.
Yes, Manoj.
The moment you knew, you filed the petition. There is no delay.
Yes, Manoj.
This is the argument.
This is the argument.
Fine. Yes, Mr.
Malad, I am for the fifth respondent. Malad, in this case, the 55 acres of land was assigned in favor of 39 persons in the year 1981. They were issued Pata certificates also. In 2004, Malad, since they failed to bring the land under cultivation, which is one of the conditions of assignment, in 2004, Malad, after issuing notices to these 39 persons, Malad, the assignments have been cancelled, land has been resumed by the government. In 2004, as soon as this order has been passed by the RDO, which was impugned in the writ petition, Malad, they received the order, and Malad, I am a representing fifth respondent, which is a factory abutting to this particular land. I am an export-oriented unit. My lord, I require some additional land for the purpose of my factory purposes. I requested the government, my lord, to allot 12 acres out of this 55 acres of land to me for the purpose of my factory purposes. Then, my lord, that was under consideration of the government. These 39 persons whose assignments have been cancelled approached me, entered into a MOU. They received money from me saying that, my lord, our assignments have already been cancelled, and you please pay us some amount so that we will not claim this land any longer further. MOU has been entered into, my lord, they received amounts also. That happened in 2004. In 2006, out of the 39 persons, only 12 persons came before this honorable court, filed the present writ petition. They stated in the writ petition, we are not aware of this proceedings of cancellation of assignment for the last 2 years. Now only we came to know about it, so now we are filing the writ petition. In 2004, my lord, they entered into MOU with me, having known about the cancellation of their assignment.
1 minute.
Yes.
Have you typed that order? Declaration of result. Have you typed that order? Declaration. Type it immediately. It's urgent. 3 lines order, 4-line order. Yes. Please.
Yes. So, my lord, government made in the writ petition that they came to know about these proceedings of 2004 until 2006 is incorrect, because in 2004, after the assignments were cancelled, they entered into an MOU with me, received money from me, and also my lord said that they are not going to claim this land any further. All the 39 persons. Out of 39, my lord, I filed along all these documents along with my counter affidavit.
Yes.
There is no reply filed to it.
May I only submit one thing, my lord?
Anything else?
My lord, may I?
reply. Manoj will kindly have a look at the MOU that is being relied upon my learned senior counsel, Manoj. The MOU is an unregistered MOU. All that signatures are forged signatures. They are not obtained from us. If I had signed the MOU, there was no reason for me to come before this honorable court and file a writ petition in the year 2006. I wouldn't have come before this honorable court and filed a writ petition. And in fact, Manoj, may I only say
These are the ways of the world. This is how people behave. Why you would come, your clients know best why they came.
Manoj, may I only say
But in any case, we can't go into this question whether it's fraud or not.
Manoj, in fact, that aspect should not, may I only submit this one, that aspect should not be considered by by this honorable court. The purpose of determination in this present appeal is my respectful submission. Because my respectful submission is that the provisions of the act have not been followed. There's a procedure which has been prescribed under the act for resumption. That procedure has to be followed, and there are judgments of this honorable court which state that if suo motu revision is being done by in the collector, that cannot be done after a long lapse of time. Here in this case, the land allotments have happened in the year 1980. Suddenly in the year 2004, because the respondent number 5 has applied for this land beside this industry, the government comes up with a case that these landless poor are not cultivating the lands. What is the proof that they've submitted for the purpose of coming to the conclusion that they are not cultivating the lands? There is no proof at all, except for their own report saying that they are not cultivating the lands, and on the basis of that report, show cause notices appear to have been issued. On that basis, the cancellation is done. My respectful submission is this: show cause notices were never issued to us. We were never given a chance to reply. The Act specifically prescribes that without my explanation being submitted, no resumption proceedings can be done. The Act does not state that without taking my explanation, he could proceed, even though there is a lapse of time, even though I have not submitted my explanation. The respondent number 2 could not have proceeded, is my respectful submission. Let me kindly have it on Monday.
No, nothing. You have argued so well.
I'm sorry.
We were about to give you a compliment, Mr. Why? Don't this thing. You have argued it so well. Yes.
I'm sorry.
Arguments heard. No, very well. We are telling you, division bench is telling you what else.
There's a petition. May I only
result for delivery of judgment.
May I only submit one thing?
Yes.
The connected writ petition arising out of the same batch.
Otherwise, you keep on. Now. Yes.
This one connected writ petition which was filed later on.
Come up. Same order will be passed. What is or we can, if you want, we can pass that order in that your case also.
Yes, ma'am.
Which case? Same arguments, Mr. You appear senior.
I don't know about any connected matter.
Let it come. Let it come. Let it come.
Your Lordship, may I make a mention? I'm sorry, myself and my education record are held up in item 55. My lord.
He has argued very well.
I may be permitted to give a short brief that status submission within 2 days, sir.
Written submission. Wants to give written submission. The other side should also be. The other side is not there, then they should also be.
I inform.
Yes, madam.
My lord.
He wants to give written submission. By tomorrow you give.
I'm sorry, ma'am.
No, it's all right. He has argued well. We want to tell you, your junior, this is the opportunity. This is how your contribution is to the development of the bar, permitting him to argue a case.
Very, very pleasant.
No, this is your contribution to the development of the bar. Because of you, he has got an opportunity to argue. And he has argued well. We told him also.
Achha.
We have no instructions from the party.
Huh?
We have no instructions from the party, my lord.
Learned counsel for the petitioner submits that he has no instructions to argue the.
So the grievance, let's say in the writ petition, as let's claimed by them, let's that they have made an applications for regularization pending that let's the authorities are trying to disperse. Is the case, let's. There's no application as such, let's are filed before this court. My first submission. Second aspect, let's even as per the pleaded case. At paragraph 23, minutes, eviction orders have been passed against the petition.
So you should make a statement that you will not dispossess them except in accordance with law. That's the end of it.
No, minutes, the para 23, minutes, the very content.
No, you will forcefully dispossess them.
Evictions orders have been passed against them. That is the admission.
This is the only prayer. You cannot, you enforce the order of eviction. Who is preventing you? Mister, we need to tell you what to do. That also. Huh? You should say that we will not do it. You do it in accept. You do in accordance with law. Implement the orders of eviction.
And on the last occasion, Mallards, they have relied on an SLP which is pending.
Nothing, nobody is relying on anything.
And Mallards, as per the docket dated 1/11/22.
1/11?
They have reported that Mallards
survives for adjudication.
And
nothing, Mr. No, none for the petition. In this record, perused in this petition, the petition.
That's easier.
You haven't done anything about FTL level, right? Huh? No, no, we remember you. You are appearing for this thing, no? We know this is not the case. You will not appear in a public interest litigation. But what have you done? We remembered suddenly that you are arguing that. Huh? Forget, no, have you done it? No. Done it? Okay.
The present application before my lords is application 3 to recall my lord's order dated 4/11/2011. R6 my lord was
4/11?
4/11/2011.
What is that order?
The sixth respondent my lord, it was default. Notice was on the ground. Patta was not. It was not.
Oh, that is that this ex-serviceman.
Yes. My lord's
we have forgotten everything about this. This is the best thing. Again, argue then whole matter. So we will have to.
Lord, I've served all the papers on the office of the advocate.
4/11/2011.
Yes, well, on that day, the sixth respondent, Patta was not paid, sixth respondent.
So name was directed to be deleted. So we will have to issue notice of this IA to him.
Please permit me also to take out person.
Heard on IA 1/3 of 23 issue notice and then in edit.
May please.
Which the writ petition was filed challenging certain provisions, my lords, of the Andhra Pradesh Entertainment Tax Act 1939. To be specific, my lords, by insertion of section 15A, my lords, there was a new levy introduced, levying entertainment tax on cable service, my lords, specifically on master cable operators. Apart from the challenge to the provisions, my lords, the impugned notice at page 70 was also challenged as being in violation of natural justice. My lords, straight away I can submit, my lords, that the challenge to the virus may not be necessary, my lords, today because there's a judgment of the Honorable Supreme Court which considered a similar provision and has taken a view against.
Which provision?
My lords, I may be permitted to pass on compilation. I've filed it with a memo also.
No, which provision have you challenged?
My lords?
Which provision have you challenged?
My lords, the provisions are as stated in the prayer, my lords, section 3, 10, 15 capital A, 15 capital B and C. The important provision is 15A, my lords. It's extracted on page 5 of the.
No. So this has validity has already been upheld.
Not the same provisions, my lords, but similar provisions raising similar contentions, my lords. The Supreme Court has held that. Not the same provision. But essentially, my lords, there was some pleas taken.
So now what survives?
My lords, what survives is that in a similar batch of matters, which is at an order, my lords, which is at page 2, my lords, of the compilation that I've just given. Similarly placed dealers had approached this honorable court, my lords, that the demand notices were summary in nature and no opportunity was provided, no show cause notice was given, objections taken, no quasi-judicial process was granted, my lords. In a similar case like that, the honorable court was pleased to pass orders at page 2, my lords.
Same terms.
Same order maybe.
Petitioner counsel, my lord, in fact, this similar provisions, in fact, the legislative competence to tax the entertainment tax, my lord, by the state government was challenged.
But what is this order? Why it can't be passed?
My lord, in this case, my lord, they are not pleading there is any violation of natural justice.
My lord, page
In
56
those
of the
cases-
affidavit straight
in
away,
those-
my lord.
In those cases, on that ground, my lord, I have not seen those writ petition. Maybe on that ground that might have been remanded back, my lord.
Which?
Internal page 56 of the affidavit, my lords. Somewhere around the middle, my lords, probably about 12 lines from the top.
Para 21, 22.
No, my lords, it's the writ bundle, my lords. The writ bundle, internal page 56 of the affidavit.
We have 56. 56.
There's no paragraph.
There are two paragraphs in our copy.
My lords, I'm following the bottom pagination, my lords, page 56, internal page 56, my lords.
Internal page 56 is 61. No opportunity has been afforded.
Yes, ma'am. I've made clear readings, ma'am. And page 70 is the impugned order, if my lord's
You
place.
give him a copy of this order. He is not very.
The affidavit is part of the record.
No, this.
Yes, I've
Copy of-
circulated. I've circulated.
Huh? Give him.
I've already given, ma'am.
Just now furnished.
No, then, right, we'll dispose it of same ground.
My lords, page 70 is the impugned order. My lords would just see for a moment.
Array, not necessary.
My lord, obliged. My only endeavor, my lords, is even without a pleading, my lords, it is very apparent from the notice itself that there's no opportunity.
Right. Yes, Mr. Correct.
Yes, ma'am. My lords, one more request, my lords. I was instructed to seek time, my lords, but I did not want to come in the way of my lords.
They never come in the way of dispensation of justice.
Therefore,
Very good.
I only pray that it may be recorded, my lords, my request.
Huh?
I only request that my prayer for time may be recorded.
No,
because I was instructed to seek, that's all.
Oh, instructed by whom?
By the petitioner, my lord. My lords,
We are not bound. We are not bound by
I'm
instruction.
only making a request.
Issued by petitioner or nobody for that matter. If you have this thing, don't appear then. You have argued it reasonably well. So why should you? Yes. The petitioner, mark the present petitioner is a private limited company and registered. Which is item? This was 59. 59.
May it please, Your Honor. Appears on the petitioners of this matter. Sir, prepared a list of dates for your lordship's kind convenience. Matter arises under the Land Acquisition Act. Your Lordship. The challenge is to the 4-1 notification under the old Land Acquisition Act. Under challenge is to the 4-1 notification and the Section 6 declaration issued by the government. Your Lordship.
What happened? There is a stay.
There was no stay, Your Lord.
Then award
has been passed. I may bring it to your lordship's notice. Award was passed. Award was challenged also. Subsequently, the challenge to the award was dismissed for default. But then the this challenge to the notification, your lordship
does not survive.
Only one
after the award has been passed, and which has been technically binding on you in view of the fact that dismissal for default till today operates.
With regard to that award, your lordship, with regard to 4-1 notification, the challenge, my humble submission is, your lordships, that this writ petition challenges the 4-1 notification.
This you can argue anything, but you ask yourself the right question. You appear to be a sensible person, right? Like if the award has become final, can we examine the challenge? What if your can we allow your writ petition quash the order under notification under 4 and 6, and the fact remains that the award is binding on you? This challenge is academic. Award has been passed when?
Your lordship, sir.
Passed on which date?
(16/10/2007), your lordship.
And it was challenged in which writ petition?
WP number, your lordships, 23552 of 2007. 23552 of 2007. And
it was dismissed when? You were the petitioner, right?
I'm the petitioner. I was not. The bundle came to me on no objection, your lordship.
No. You were the petitioner in WP 23552, right?
Yes.
What happened to this petition?
The petition was dismissed on 23rd December 2010, your lord. Initially, the challenge to this, the 4-1 notification and also the award were dismissed for default. Thereafter, the petitions were restored. Because
when was it dismissed finally, Mr.? We are not in
23rd December 2010, your lord. It was finally dismissed.
All right.
But
so this order, did you file an appeal?
Because there was an observation by this court in on 23/12/2010 that since these writ petitions are restored to file, no further orders are required in the writ petitions challenging the award. That is the order passed by this court. May I pass on? I have only one copy of the order. Your lordship may permit me to pass on.
Yes.
I'm sorry, your lordship, I have only one copy.
Yeah, what has been appealed, nothing happens. So in these petitions, you are challenging the validity of the award, right?
Yes, Your Lord.
It has been dismissed.
That has been dismissed, but 3007 is restored to file.
Which 300?
This is 3007. Challenging the 4-1 notification.
Both these petitions are dismissed. How you are saying?
No, there were two neighboring landowners who also challenged the award, Your Lordship. Their challenge was also dismissed for the award.
Academic reason that original WP extend to original numbers. Arey, Mr. We don't know what you are trying to say. Subsequent to filing of this writ petition, the fact is that an award has been passed. You had challenged the validity of that award in a separate writ petition. That has been dismissed.
Yes.
Then what? I mean, that dismissal of that writ petition has attained finality. Right?
Yes.
So now this challenge to notification 4, 1 and 6 is rendered academic. Because even if we allow your petition, we cannot set aside the notification under 4 and 6 because we cannot touch the award. That has attained finality.
So I am also challenging the alignment also, Your Lordship. The alignment.
Alignments, we can't decide
the exercise of
under Article 226, we cannot decide alignment because we are not, none of us are engineering graduates. Nothing, no experience on alignment. You have done engineering and thereafter, good, then you are also sailing with us. You also don't understand. So let us not venture into an area of which we don't have any idea. What should be the alignment?
Alignment is challenged on the ground that 6th and the 7th respondent have been benefited out of the acquisition. That is my understanding.
You understand, right? What we are trying to tell you is that, see, eventually we are not sitting here to convince you, right?
Yeah.
It's just out of this thing you helped us, therefore we are telling you. We are not sitting here to convince. I mean, this order, agreed, we will make available the certified copy to that set. Right?
Very well, I'll leave it.
Order. Madam, this writ petition. You are the owners of land, which
in survey number.
You have not given the details, Mr. What type of this thing you prepare? Why it was required?
4-1 was issued.
Why?
Sixth declaration was issued after.
Why? What purpose? What?
Outer ring road, you lot. Outer ring.
Construction of outer ring road.
Yes.
All right. All right. Yes. Yes, ma'am. Facts in this petition, comma.
Please, Your Lordship. In this matter, the respondents have filed their additional counter in this matter, Your Lordship. Your Lordship may kindly give us some time, Your Lordship. This matter pertaining to agency area lands, Your Lordship.
Argue.
Senior counsel has to argue.
Yeah, nothing. You are senior counsel. You have seen, right? You are everybody. We have heard this matter on 31/8 also.
Yes, Your Lordship. On the previous occasion,
Yes.
Your Lordships have directed them to submit a additional report, Your Lordship, wherein they have submitted it yesterday, Your Lordship. They have to verify with regard to that, Your Lordship.
Nothing verified. This is a public interest litigation, right? It's not adversarial litigation. You are not getting anything out of it. Don't appear. Simple thing. Public interest litigation. You are making it as an adversarial litigation and seeking time to do what this thing is not. Forget about it. You have done a good job. Filed the petition. We have taken cognizance. Nothing. No senior counsel in PIL. Nothing. If you want to argue, fine. Otherwise, we can manage without you also. This is not a this thing, regular petition, right? We will deal with it. Don't worry. Sit down. Relax.
My instructions.
No, nothing. No instructions. This is a public interest litigation where petitioner loses locus after bringing it to the notice. So you know that Sheila Barse thing. Don't like adjournment and this thing. How long this will be pending?
I understand.
Very good. 16 years. After 16 years, if you understand, then it's very good. But
my humble submission is
no,
that
don't waste your energy, nor this thing. Don't compel us to force our energy. Let us use it in something constructive. It will not be adjourned. Forget about it. You have seen we have not granted adjournment in any case, except where petitioner has died. A counsel for petitioner is expired. In that case, we have issued notice. This is a public interest litigation, mister. You are not going to get anything out of this. Why are you seeking adjournment? If you have filed it for public interest, you should be interested in arguing the case. Right from the case has been called, it's included in the list since yesterday. Since yesterday, you are waiting for this opportunity to tell us that I want adjournment. This is how, Mr. Examine your approach. That since yesterday you are waiting that the moment it is called, not called, very good. If it is called, I will seek and pray for adjournment. Not fair.
on like
This is no.
Counsel is on like before.
No, nothing. This is a public interest litigation. Forget about it. This counsel on legs, whatever. This does not apply. It is not an adversarial litigation. Even if petition is dismissed, nothing is going to happen. It's our duty. We have taken note. If you want to assist, then otherwise, please do not force us to waste our energy by unproductive things. Please sit down. If you don't have to say anything, sit down. What is it, madam? Where is have you filed
Counter
counter?
is filed, Your Lordship.
The counter is filed means so.
Paragraph I
You will argue.
Yes,
He is not arguing. You will also not argue except by saying counter is filed.
The writ petition is filed to protect the tribal lands, Your Lordship, and basing on the same, Your Lordship, already
No,
committee.
when have you filed? When have you filed additional counter affidavit?
Additional counter is on 310, Your Lordship.
310. Ask for a copy.
They pass. USR number. Earlier detailed counter is filed, your lordship, and your lordship directed us to get the instructions. Till now, what is the action we have taken, your lordship? We have stated in paragraph 4, your lordship. We have given the district wise particulars also, your lordship, in page 3.
Yes. We have given details. Yes. What can be done there?
I read, your lordship. The competent authority deputy collector disposed as 50,805 cases in the 8 schedule areas districts reorganized from 3 erstwhile district Warangal, Adilabad and Khammam, your lordship, covering an extent of 2,574.24 acres. It is submitted that as many as 81,334.91 acres are restored to STs in these districts, covering 22,815 beneficiaries, as indicated in the following statements, your lordship. We have given number of cases detected and an extent covered, your lordship, number of cases disposed of, and extent cover acres, restoration of land, your lordship. For all the 3 districts, your lordship, we have clearly stated. In earlier counter, your lordship, we have in the counter also we have stated, your lordship, that all the Kone Rangarao committee given some 104 recommendations, your lordship. According to that, 90 recommendations were already considered, accepted, and the government was issued also GOs, your lordship, to consider the same. And even regulations were also came into force, your lordship, and act was also came to protecting the lands of the scheduled tribes. So we are continuously protecting the lands of the scheduled tribe areas, your lordship, by
Please see your additional counter.
yes, your lordship.
You have given a table, just make us to understand these figures. You have submitted 3 columns as extent covered.
Yes.
It is 4, 6 and 8.
4, 6,
4 is coming to around 2,06,028.
yes.
Then 6 6 is coming to around 2,05,74.
Extent covered, Your Lordship.
Yes.
Yes.
Extent covered is in 4, 6 and 8 columns.
With regard to Mancherial, Warangal district, Your Lordship, 2 lakh.
No, again, see 8, you have given a figure of 81,334.
Yes, Your Lordship.
What is the total extent covered? You have to take all these into
All the 3 districts, Your Lordship, we have calculated.
no. Out of the all 3 districts, how much has been covered, how much has been restored?
Last grand total, Your Lordship, you have clearly stated.
Yes, you have to add all these 3 columns, right?
Yes, Your Lordship.
So it goes beyond 5 lakhs. Almost nearly touching 5 lakhs. Out of which you restored only 22,815 acres.
8164 and 23778, Your Lordship, and one more is 49392.
So, madam, the question is totally how much land is covered according to you in all these 3 districts?
That is 81,334, Your Lordship.
Only column 8?
Yes, Your Lordship.
Then what is column 4 and 6?
These are with regard to the 3 districts, Your Lordship, Warangal, Mulugu and Mahbubabad. Now, earlier it was only Warangal district.
Okay.
So we have classified 3 districts. And second, 4th and 5th, 6th is Adilabad district, Your Lordship, Asifabad and Mancherial.
Yes.
And 7th and 8th, Bhadradri, Kottagudem and Khammam.
Okay.
With regard to the 3 districts, we have given separately.
That's fine, but if you add this total, how much it is coming? Extent covered in 4, 6 and 8. It almost touches 5 lakh acres. And as per your statement, that is restoration of land, in column 7, it is only 22,815. Please explain on those figures.
It's the number of cases detected, Your Lordship, first column. Number of cases detected, extent covered acres.
If my lordship's permit. Lordship, there is a small calculation here. If at all this can help your lordship, I would like to submit your lordship. Lordship, there is the entire extent of 2,05,74 acres, your lordship, wherein they have restored only 81,334 acres, your lordship, wherein 1,19,240 has to be restored to ST people. It is stated here, lordship.
This is with regard to the 3 districts only, Your Lordship, we have stated.
Read para 4.
Yes, Your Lordship. In addition to para 8, it is submitted that the competent authority special deputy collector disposed as many as 50,805 cases in the 8 schedule areas districts reorganized from 3 erstwhile districts of Warangal, Adilabad and Khammam, covering an extent of 2,05,74.24 acres. It is submitted that as many as 81,334.91 acres are restored to STs in these districts, covering 22,815 beneficiaries.
Remaining area of approximately 1,20,000 acres has to be restored as per your own data. Para 4.
81,334.91 acres are restored, Your Lordship, to STs in these districts.
Total areas, madam, 2 lakhs. Out of that, 81,000. So remaining 1,19,000, who will restore?
That I'll clarify, Your Lordship.
Huh? Yes, write down in compliance of the order. Date.
I am appearing for respondent.
Which is this is PIA. Yeah.
In this matter, my lord, I am appearing for the respondents. I filed recently Wakalat, my lord, after change of the standing counsel for GHMC. I am handicapped with the bundle, my lord.
No, nothing, no handicap. The handicap will be removed after some time when the petition is decided. Handicap will be removed.
Sorry for the.
No, fine. It's you have for respondents.
Yes, ma'am.
Not filed any reply. Page 14. No reply for. No representation from. No, the moment we dismiss the will file, I don't see memo. What are we sharing to understand? It was much to hear this. So, what is? It is mentioning, you know, somebody. What is? Previously, it was listed before DPM. That's right. Outer sheet C. GSCV. Always listed before DG.
Yes.
You show the name of that council in the display, not showing. Show the name of the, it should immediately show, right?
This council, what is the status of this restaurant? It is functional.
He doesn't know.
I have to get the instructions.
You don't know anything.
I have to get the instructions, but tomorrow it may be taken. Whether restaurant is running or not.
We display it. None for the petitioner, Mr. So and so. It up.
Sorry for.
Hello, so I'm appearing on behalf of the respondent of the 6 matters matter. These writs this writ has been filed challenging the issuance of tender in favor of the respondent on the 6 matters. In respect of 2 projects, one the state of Andhra Pradesh, which was the Knowledge City Vizag campus, and the other project was an aerospace project based in the city of Hyderabad. Subsequently, my lords, the Andhra Pradesh government had cancelled the both the projects, my lords. Had cancelled the Vizag project in favor of the respondent number 6, as well as the Telangana government has also cancelled the same in favor of the respondent number 6. As such, the writ petition has become infructuous, my lords.
That you should say in the beginning, madam. You are making us read.
No, my
and we have, this is, you are here to assist.
Yes, my lords, but
No, you are here to assist the court, not to make our life difficult, right? None for the petition. None for the petitioner in this writ petition, comma.
Allotted to me. Subsequent.
Who has completed, madam?
No information.
You have not completed. Submits that that even though tender was awarded to her, '64 to '72 batch. Yes.
My lord, section validity of section 22A of the Registration Act, my lords. My lords, in fact, a full bench decision, my lords, covers the field. In fact, my lord, they'll have to overcome that 22A, my lords, which was impugned in various batch of writ petitions. Since, my lord, the learned single judge's view, in 6 judgments, some inconsistency was found. Therefore, the matters were referred to the full bench. Full bench has exhaustively, my lord, have dealt with the section 22(1)(a) to E. Not when that certain directions were given by this court. When an appeal is preferred, since the virus of very 22A is pending before this court, the matters are sent back to the Honorable our High Court. They will have to justify, my lord, as to how it is apparent against to the fundamental right.
Yeah.
Broader.
Yes, you are appearing.
I am at item 72.
Yes, Mr.
65.
60.
64 to 70.
65.
6254.
Yes.
Huh?
Lordship, kindly take up 9141. I give
66.
synopsis.
66.
66. 66. I give a synopsis also.
Rubber. Well, Hmm? Yes, given. Is given. In the street also. So did you give any synopsis? Because
My lords, I prepared a note, my lords.
now this has to be heard exhaustively.
My lords, there is nothing much to be exhaustively heard. The matter is very simple. The full bench has elaborately dealt with as to the, my lords, with regard to the legislative competence, my lord, the state has got this competence.
If you have any synopsis, you rubber.
The validity aspect is not there.
That has been touched upon, the natural principle, everything has been touched upon by the full
All
bench
right,
of
all
this
right. We will hear, no problem.
Yes, my lord.
Yes. Yes, Mr. What is it?
Just
What have you challenged?
I have challenged, initially, the petition made a state lead for 19, dated 19/11/2000 for registration.
A petitioner is a student.
Challenging section 22A and also
We have just seen verification petitioner is student aged about 20 years, very early into the litigation, right? Now he must be what? 35, settled now. Huh?
his father must have purchased it. This document was submitted for registration, and the sub-registrar rejected on the ground on page 38 and 39.
Section declaring 22A
A of the
AP Act.
Yes.
Validity of section
Act 19 of 2007. On submission of this this was rejected by the respondent number 3, sub-registrar, page 38 is order. And after that, I'll go to the sections. Page 38.
one. This is what your synopsis.
वही उस पे ही जाओ मतलब किधर आओ बोला मैं
Para 4 and 5 are my contentions, precisely. Yes. The same is the order note, page 38. Page 38, Your Lordship. The order of the sub-registrar.
No, it must be in view of 22A.
Yes,
So
that's all. That's all.
It's
a confirmed minute.
So we should, straightway we should, what is 22A,
Yes,
what is house?
kindly take section 2. Prior to that, in fact, there was an amendment in 1999 on the ground the public policy.
Yeah, what is 22A, madam? What is prohibitory list?
The following documents shall be prohibited from registration. 22A, capital A.
Arey, madam.
PG fellowship holding the same book, not based in
One minute. Registration. Prohibition of registration. What? Please read.
The following class of documents shall be prohibited from registration, namely documents relating to transfer of immovable property, the alienation or a transfer which is prohibited under any statute of the state or central government. This, in fact, we have no quarrel on that. B and C are important for our purpose. Document related to transfer of the property by way of sale, agreement, sale, gift, exchange, lease in respect of the immovable properties owned by the state or central government. Executed, well, this sentence most important. Executed by persons other than statutorily empowered to do so.
So you don't challenge 22AA.
A in the sense, not 22A, B and C is more affected by me.
B and C.
B and C. Because other acts, Your Lordship knows ULC Act, Section 5.3, Assignment Act, Section 3. These prohibitions will not certainly laudable object is there that is binding on these authorities. B and C are more affecting because what's happening is that C document relating to transfer by a sale of so and so, exceeding religious charitable institute, per view of the Andhra Pradesh Charitable and Hindu Institutions Act, or falling in the box 1995 executive person than Your Lordship kindly note other than those statutorily empowered to do so. D may not be that also may not permissible maybe agricultural land, agricultural urban lands declared surplus areas so and so. E is any document or a class of document pertaining to the property state government may by notification prohibit registration with the award accrued
Interest of central government or state government, local bodies, educational, cultural, religious, charitable, those who are civil, criminal, courts, direct, indirect tax, other laws which are likely to adverse affect these interests. 2. For the purpose of this class subsection, state government shall publication after obtaining reasons for and full description of the properties furnished by the district collector concerned as the manner may prescribe. 3. Notwithstanding anything contained in the registration shall refuse the registration document which notification issued under subclause E1 of subsection 1. State government has a suo motu 4. State government has a suo motu application on any person giving the final orders of the High Court on the Pradesh may proceed to denotify either in full or part a notification under subsection 2. Well, this subsection 2, 3, 4 is related to Milord 22A small e Milord. These notifications 2 and 3 are concerned. The government has not issued notification. Now, Milord, by virtue of what the sub-registrar is saying that a list is forwarded by the district collector. Now, after the full bench judgment, they framed some rules under the Registration Act. And those rules, whatever the list they forward as a government land, whatever the list they forward, B and C, temple lands, work lands, registrations are prohibited. Thereby, government will not, the district collector decide the title. District collector claims this land is a government land. Then he sends it. This document is totally prohibited. What are the documents he sends by the list? My first submission is that, this, by reading of the literal meaning of literal B and C is concerned, it is only says the authorities under the Registration Act, sub-registrar, only to see whether the document of the state government or the concerned temple or property has been presented by the proper person who is authorized by the respective departments or the institutions. If you, Lordship, must see the language of it. I'll just read subject to repetition, Milord. B. Documents relating to transfer of the property by sale or agreement of sale, so and so, in respect of immovable properties owned by the state or central government, executed by persons other than those statutorily empowered to do so. Those documents, certainly a prohibition will apply. Not Milord saying that simply a list is forwarded. Hyderabad contains a large number of lands, Milord, Lordship must have come across with after coming to this honorable court, lot of evacuee properties, assigned lands, Sagir lands, Inam lands. And under the various enactments, Milord, the persons have been in possession. And Milord, number of litigations still, Milord, Inam and Jagir, etc., all are pending. Now, what the district collectors are doing, they own this thing, the MROs, they ask for a list. Whatever they want to include, they send the list. That list is forwarded to the sub-registrar arbitrarily. There is no mechanism of anything of deciding or notice, nothing.
No, Mr. One thing, like power under 22A is being misutilized or misused is a different thing.
One thing.
Then we are on the question of virus.
Yes, yes. But why I'm saying is that,
like,
first my submission.
What is the challenge?
Challenge is that, Milord, under section 17, under section
government is not empowered to enact a provision like
Milord, this is contrary to section 17 of the Registration Act, which says central. This is a state amendment. Milord, there is no presidential assent under Article 254(2). So, Milord, the Central Act, section 17 mandates even the transfer of property.
What this 22A is contrary to section 17.
17 of the Registration Act.
If you formulate your submissions, then it will be easy for us to understand, right? So,
It has the president's approval, my lords.
It is not. We have specifically denied no counter.
all right. Yes. So, section 22A.
Act do not say. You have assent the president. Give me comment. Or refer. No counter is fine.
Is violative of section
17.
So,
being arbitrary may not violate of
No, it is violative of section 17.
17 of the Registration Act, precisely. Your Lordship may kindly come to section 17.
Yeah.
Section 17 and also transfer property other acts. Documents, the following documents shall be registered. If the property which is related situated in the district which they have been executed or on after which Indian Registration Act, so and so, so and so. The act comes into force, namely A. Instruments of gift, B. Other non-testamentary instrument purport to operate, create, declare, assign, limit, extinguish, whether present or future right, any right, title, interest, whether vested or contingent, the value of 100 rupees, so and so. And Your Lordship may kindly see also non-testamentary C. E concern non-testamentary instrument transferring, assigning any decree, order of the court or anything, decree purport to declare, assign, so and so. Well, this section makes me to get registered, and the sub-registrar has no jurisdiction once I submit a document in respect of the particular property, which is under B, A and B, etc. He is bound to register it. He cannot refuse. The refusal is prohibited totally. A sort of an injunction, in fact, a permanent injunction against me. I have the property, my property, in fact, this particular property since 1955 onwards, the revenue record shows about it, property, etc. Now, by virtue of this 22A, the list forwarded, my right to execute is.
Please don't mix up. We will come to misuse of power. This is a different thing. You are right now telling first submission 22 is contrary to section 17.
Yes.
How?
Because I am entitled to my document which I submit for the document for registration. Entitled for registration. Whatever document I submit under A and B of the section 17, the sub-registrar shall register it.
That right is taken away by
section 22A.
Yes.
And when a second submission is the 22A, without any guidelines, sending the list, without any adjudication or anything mechanism, sending the list is almost arbitrary provision.
Where sending shall publish what list?
Well, the collector sends a list from to the sub-registrar.
Provision?
Well, under the rules they made thereunder, collectors are 2 minutes.
No, we are, Mr. Please tell us your submissions first, then you can elaborate. So that we understand what is the challenge. You have just now told us section 22 is violative of section 17 because section 17 confers a right on you to get register the document. That 22A takes away your right.
Yes.
What else?
Section 22A is arbitrary. Prohibiting in the name of saying that is a class of documents properties belongs to the state. Unilaterally, without any mechanism of adjudication, a mechanism of provision is an arbitrary. Section 22 itself is an arbitrary. And third is that the object of the Registration Act.
Arbitrary, why?
Arbitrary when itself, the state itself declaring as the owner itself and property.
As unilaterally can declare itself to be the owner.
Owner and grants a permanent injunction.
Just unilaterally.
And consequently grants a permanent injunction. From registering. Until what? Nothing about it. Until I should get a title decided in a competent court. Which is totally arbitrary. These two are main present submissions. Third submission subject to my learner friend says no counter is fine.
Act itself says.
Act which where do you get that?
Act itself.
What you say that no presidential assent?
Assent is given, sir. Well, these are the principal submissions, sir. These are the principal submissions. Well, the dealership knows when the object of the Registration Act, dealing with the documents, not document transaction embodied therein. Well, that is what the Supreme Court has been saying. In fact, earlier, when this act, under by way of Act 4 of 99, 22A was introduced, saying that a document which is opposed to public policy will be prohibited by virtue of notification. That was struck down by the Honorable Supreme Court, and it was followed in this year also. In fact, that is Rajasthan case. The notification and the rules section and the challenge is extracted in para 5 of the judgment.
Para
5. High Court, the improved judgment inter alia held that Section 22 of the Act confers arbitrary powers on the state government determined regard to declaring a particular document being opposed to public policy. It is opined that the question whether transaction is so and so is not cannot be determined only by the courts, not by the sub-registrar. Improved legislation invades the right of citizens to deal with the property. That's the whole arbitrary, unreasonable. The object of registration of document not achieved by the improved legislation. Act deals with the deeds, documents, not transactions, not in the other. Non-registration of document, per se cannot be so and so public policy. Section 6 extracted, 22A. Documents registration which is opposed to the public policy, state government may by notification in the official gazette declare registration of any document or a class of document opposed to the public policy. Notwithstanding contained in this registration, officer shall refuse to register any document to which a notification issued under subsection 1 is applicable. Notification contained in annexure 3, 4, 6 and 7 as under. In excess of the this is a notification issued that under provision that portion. In excess of the powers under section 22 of Registration Act as applicable in the state of Rajasthan, hereby declares.
No, but this is, different provision.
Yes.
Sweeping provision, any class of documents opposed to public policy. Public policy, you know what Supreme Court has said.
Yes.
Very relative, this thing, concept, incapable of precise definition.
So, definition not possible.
Like this confers a very, wide powers.
Yes.
So then.
Well, then the 54 below the object of the act.
Now, what has been held then in this case?
Well, this was struck down, my lord. Section 22 was struck down. Notification is struck down.
Please read.
Well, head note itself, your lordship.
No, don't read from head.
I'll just come to the provisions that that's.
Para.
53 onwards conclusions. We have noticed here that state of Rajasthan inserted 17(1) FG making a registration act, sale of so and so, attorney so and so. State went to the further amended so and so, make agreement of sales, irrevocable so and so, conveyance duty is chargeable there. According to state, despite of such enactment, sales are being effected right to sell the property and such a powers. A transaction of 2% capable of entering into the contract which does not contravene its statute does not make such transaction illegal. The contract or the powers of the power of attorney have to amend the execution of so and so is not so and so. Power of attorney except in falling under the compulsory registrable under section 32, 33 of registration also do not bar any such registration. The act only strikes a document, not at the transactions. The whole aim of the act is to govern documents, not the transaction, and thereby notices public brought. So and so field, then the registration of so and so, consequently section 49 minute, etc. has been considered, and when hence the para 57 onwards, section 52A to section 22A, those subordinate legislation cannot control the transactions which fall out in scope of it. We have noticed the effect of the power of attorney so and so for a subordinate which is not backed by statutory guidelines is not invalid. The question to be considered another angle also, a person may not have a near relative or otherwise attend so and so situated. In the absence of any substantive provision, conflict parliamentary legislative act cannot be refrained from dealing with the property any manner he likes. Such a statutory introduction would be opposed to one's right envisaged under Article 300 of the Constitution of India, and the scope of the public policy has been so and so and self-effective has been considered. Milord, and the 62. Even those at purpose, the part dealing with the public policy sector are required to be considered in the conjunction so and so. The question arises with regard to the statutory powers and the guidelines so and so. And when it is in the contention, then it has been concerned. We have the opinion that sub-registrar 67. For the reason we not find any merits with appeal and dismissed accordingly. So far as the state is concerned, we have the opinion that orders passed by sub-registrar refusing document and notification so and so would not be reopened.
What is the reason why it has been struck down? That is not right.
This direction of the High Court has been upheld, which para 4 when the High Court declaring that act is not valid. Leaving the public policy from para 62 onwards, even the said purpose, the part of dealing with the public policy section, contract is required to be construed so and so. Further question is whether having regard to the doctrine of separation of powers, what is essentially within the exclusive domain of judiciary cannot be delegated to the executive unless policy behind the same is finally laid down. A thing which itself is uncertain cannot be guidelines for anything, cannot be set to providing sufficient framework of the executive work under it. Essential function legislation cannot be delegated so and so. Then para 65, contention is an affluent herein that state being higher authority having been delegated the power of making declaration in terms of section 20 of the act would not be abused, restated, rejected. Such a question does not arise herein as a provision has been held to be ultra virus of the Article 14 and 246 of the Constitution of India. The contention is the effect that this court would not interfere with the policy decision again devoid of merits. A legislative policy must conform to the provision.
Why it has been struck down?
But that is para 4 only they mentioned the para 4 the High Court order they have mentioned. The rest of all the guidelines have been given, the appeal has been dismissed, state appeal has been dismissed. Para 4 Your Lordship will get it that the High Court has struck down the amendment.
No, why? Why 22A has been struck down?
The reason for the Supreme Court also cannot from para 60 to 67. All these reasons when the Supreme Court para 4 year judgment. By reason of the impugnment, Rajasthan High Court declared Section 22 of the Act as inserted in Rajasthan Amendment Act 1976, being Act 16 of 1970 as unconstitutional, and consequently notifications contained in Annexure 3, 4, 6 and 7 the writ petition was quashed. Sub-registrar was also directed to register the power of attorney 16.7 which was presented and so and so. Again, as the state preferred, the writ petition. Grounds, I have para 5 grounds is concerned, section 22 extracted. Ultimately, Supreme Court made various facts were
We will tell you.
execution of.
We will tell you what is the reason. Don't hurry through, Mr.
Para 53 I read so because they cannot make the transactions being illegal, they cannot prohibit it. Para 53 is a principle of it which I read, my lord. You have noticed that state of Rajasthan inserted so and so registration. So and so state cannot further 23 agreement of sale, power of attorney, so and so stamp duty. According state, despite of the enactments, sellers have the power of attorney with the right to sell of such a power as attorney were being executed in unspecified period. A transaction between the two persons capable of being entered does not contravene any statute would be valid in law. The state Rajasthan does not make transactions illegal. Contract Act, the Power of Attorney Act have not amended. Execution of the Power of Attorney so and so, so and so. Then section 32 onwards they have dealt with that. And the transfer of property provisions have been dealt, my lord, and para 60 to 67, my lord, they gave even when they come to such a conclusion. Because, my lord, as I said, was, my lord, 22A, my lord, I was saying that sealing properties, these are all properties, because the transactions are illegal, prohibited under the statute. The prohibition under this act may be possible. That's why I said B and C, my lord, I am only more affected by it. Not A and D. Because transaction held to be illegal. Now, state cannot ballot by without transaction being held to illegal. State itself will not declaring title itself, adjudicating itself with.
The earlier amendment was dealt with by the Honorable Supreme Court. Now that the another amendment has been made, my lords. In this, why the earlier amendment was struck down by the Honorable Supreme Court is there are 39, 43, 44, 45, 51. Those were the, my lords, issues. There are 39, 43.
That's operating field is concerned.
43,
That's a public
44,
policy, my lord.
45, 51. Now that is not the provision which has to be.
That's so, my lord. I said with the public policy, my lord, as your lordship observed, your lordship, public policy defined in each act is a different. My lord, public policy, my lord, under the contract act is different.
No, what we are trying to, this thing you are citing this, it's a different provision. Mr.
Yes.
Here,
This I am citing only for the purpose of
22A does not deal with public policy.
public policy. I am only citing this judgment is concerned. My lord, the transactions.
Therefore, you will have to tell us how this helps you.
Well, it is concerned with para 54. I have read only for the purpose of the Object of Registration Act, para 54, which only deals with.
Para 54?
Act only strikes at the documents, not the transactions. The whole aim of the act is to govern documents, not the transactions embodied therein. But here, my lord, the now transaction of the state government property, thereby, my lord, you cannot enter into the transaction. State itself decides, which is in fact under separation of powers.
No. We don't think under anywhere says 22A says 22A, it's an embargo on registration in respect of documents mentioned therein. It does not say you cannot enter into a transaction.
Obviously, when I present a document for registration between the parties, the registration authority is saying, as per the list.
That's correct, Mr. But there is a distinction. You are saying that there is a prohibition on entering into transaction. This is not there.
Prohibition in entertaining.
Registration.
Yes, my lord. There, the sub-registrar, because of what happens, my lord, I submit document, it goes into the.
Mr. You are that's the problem. You are from a legal issue. You slip into the how it is being misused. We will come to it later. How power is being misused. That's a different thing. That's a different thing. What he is doing, registrar, what government does. That's a different thing. But we are on the question of constitutionality of the provision. What is your first submission? You have only said it is contrary to section 17. So if
contrary to section 17(1),
17(1), Mr. If any provision is in direct contravention with another provision, then firstly the court will apply the principle of harmonious construction. It will read it down. That by itself cannot be a ground to strike it down. That is, some provision is in contravention of the another provision. We don't know what.
Not only contravention, the provision itself, my lord, is an arbitrary in the sense.
That is, but you have to substantiate. Merely saying arbitrary, discriminatory, this will not suffice. You have to, petitioner has to plead and prove how it is. You are not.
Since 1955 onwards, my vendor and myself are the owners of the property. Under a transaction entered, I go to the this thing. Document is prohibited. Therefore, my deprived of Article 300 of the Constitution of India, read with Section 17 of the Registration Act. And what section says? And also when my submission was, section says.
No. What is prohibited means what? Document is not annulled. Document is only prohibited from registration.
Yes, not being received. Not being received.
Right, brother. He says what? I don't know.
Not being received and rejected.
No. Document under 22A is prohibited from registration, not document is annulled or something like that. Nothing of that sort.
Essentially, when my document is rejected for registration, ultimately substance of it is meant where my entire thing is lost. The vendor's right to excise property is also lost. And my submission was
how you want to fine, Mr. This is what you want to argue. Then fine. So your right is lost. Then
right to register, right to deal with the property is lost by virtue of this.
No, how you are right? Acha. You have purchased, you want to sell it now. That's so.
My vendor, even my vendor right to transfer is not affected.
To see subsequent sales. Okay.
In fact, Registration Act, if you may see the provisions, 35, etc. Well, the scheme of the act is that the documents should be received under section 17. The registrar will only see with regard to the execution part of it and the stamp duty collection, etc. Any statutory transaction prohibited under the act. But now, by virtue of this, my lord, in respect of property held by a particular vendor, is being prohibited, injected from alienation. He cannot alienate it by virtue of this, which is a competent court of law can do, not by the state or the state function is under the Registration Act. Net result of it is such registration is prohibited.
Please tell us that if a provision of a statute is contrary to the another provision, it can be struck down as. This is what you have argued.
Yes.
Any proposition to support this. First, we have noted it down, Mr. With all seriousness, that it is, according to you, it is violative of section 17. Therefore, it is in contravention of 17. Therefore, liable to be struck down. Which citation, which case law says if one provision of one act, some provision of act is violation of another, it can be struck down.
Harmonious construction, reconcilement, etc. That's a judicial interpretation. I know your lordship, your lordship.
No. No, but we want to understand, Mr. You have to substantiate, or we will have to say that you have argued and has don't expect us to do the research on this. Don't argue. That's what we are. Be serious. I mean, you are just proceeding, concluding in a hurry. We are giving you time. There is no hurry, right? So, but you are just passing through, rushing as if you have to conclude within 5 minutes. We didn't never said. Please argue. I will have to say that we will have to say that even though such a submission is made, it is not substantiated by any case authority, any case law. The way you are arguing, just hurrying up as if we have asked you to finish by 4:30. Otherwise, no, nothing of that sort. We are, please substantiate it, elaborate it. How, what? How legislative competence, that is not the ground you have raised.
Legislative competence in the sense, this is falls under the entry 3.
Mr. We don't know, you are arguing the
yes, I am arguing. It falls under the entry 6 concurrent list, my lord. Entry 6 of the concurrent list, stamps and registration. Subject to learned friend saying that assent is consent, I could not find from my book, nor they filed any document.
Entry 6
of the concurrent list.
So there is no assent of the president.
Assent of the president is not there. And this provision, according to me, is not only section 17, even the object and the method of registration prescribed under the Registration Act provided with the Parliament is being infringed. In the sense, the Parliament only said documents for the registration. The functions of authorities under the Act is concerned only to see the executant, verification of executant, signature, etc., schedules, property situated within territorial limits, etc. Not with regard to the person who executed. Or a transaction, or the property belongs to a particular juristic person. Now the state is a juristic person in the sense is a property holder. It comes and says to a registering authority, a statutory authority, a list by virtue of this.
Mr. Ved, again you are referring to time and again list. The provision does not refer to any list. We have read. Rule 20, Section 22A you have read. It does not provide any list and this
Rules,
thing.
Your Lordship, I kindly take the rules, my lord. Rule 238. They made a rule 238.
Rule 38.
238.
238.
The district collector shall furnish a list of immovable properties falling under the clauses A to B, A and B. Subsection 1 of section 22A, including subsequent additions, deletions, or modification to the district registrar concerned and to the inspector general of registration under proper acknowledgement in form 1 and 2 respectively of the appendix 9, 11. The list shall be signed by the district collectors, this signed by the other officers shall be not be considered. After updating the entire record, the commissioner's endowment shall furnish so and so, 239B with regard to the work properties. And 240 is with regard to the properties covered by the district collector with regard to Andhra Pradesh Land Reforms Agricultural Act and Urban and City Act, etc., including subsequent additions, deletions, etc. But a proper acknowledgements. 241, the district collector shall furnish a list of the properties to be notified or to be notified under section 238, so and so and so, so and so. As the case may be, to the principal secretary of the government, levying the Department of Telangana State, publication in the Gazette in form 4 of appendix 1. But these are the rules they follow.
So,
a juristic person is holding a state is also a property holder, a centralist. And by virtue of this amendment, by right to section 17, again, your lordship may not think reputation. 17(1) is prohibited. And your lordship may see what is the scheme. Because I don't want trouble, your lordship, scheme of that 35 and 33, 31(3). Section 21 says what is the property situated with the plans, etc. to be submitted. For section 33 onwards, with regard to investigation inquiry, with regard to the sub-registrar, your lordship may come to chapter 5 of the Registration Act. Place of registration of document. Say whether every document so and so 17 so and so. As far as a document affects human property under section shall be presented for registration officer within so and so, so and so. And 29 is the police registrations. Your lordship may kindly come to 31. 31 is the deposit. Your lordship can skip it. That 32 is the person's present document. Except cases mentioned in the sections 31 and 88, 89. Every document registered under this act, registration compulsory option shall be presented by the proper registration office. By some person A, executing or claiming under the same, on the case of copy of decree order claiming under the decree. By the representative or assignee of such a person. By the agent, C is concerned by agent or such a person representative to assign duty authorized power of attorney executed, authenticated in the hereafter mentioned. With regard to some amendments 32, etc., photograph, etc., 33 power of attorney, your lordship can skip that, 34 and 35, the inquiries. 34 and 35. Subject to the provisions contained in the sections 41, 43, 45, 69, 75, 77, 88. Document shall be registered in fact unless person executed such document or the representative, assignees or agents authorized as per the aforesaid appear before the registering officer within the time allowed for the presentation under section 23, 24, 25, 26. Provided it is upon urgency, unavoidable accident, such a person do not appear, registrar in a case of so and so delay appearing does not exceed 4 months may direct that on payment of fine not exceeding 10 times registration fees, etc. Under section 25, documents may be registered. Appearance and subsection may be simultaneous, different times. Reach and thereupon inquire whether or not such a document was executed. This is the inquiry. Inquire whether or not such a document executed by the person.
Which section you are reading?
34, 34 2. 34(1), I read, subject to repetition. I'll read again. Subject to the provisions contained in this part, sections 41, 43, 45, 46, 75, 77, 88, 99, No document shall be registered in this act unless a person executing such document or their representative, assignees or agents authorized as a facet appear before the registering officer within the time allowed for presentation under section 23, 24, 25, 26. Proviso, your lordship can skip that is with regard to the difficulties in appearing. 2. Appearance in subsection may be simultaneous or different times. Then 3. The registration officer shall thereupon inquire whether or not such a document was executed by the persons by whom it purposed to have been executed, satisfy himself by the identity of the person appearing before him, and alleging to have executed document. In case of any person appearing representative to assign, he can satisfy himself for right of such a person. Any application or a direction under the provisions so and so forward to the registrar whom he subordinate. Nothing which applies so and so, so and so. And section 35 deals with the admission and execution. If all the persons executing document appear personally before the registering officer.
We'll continue tomorrow.
Yes.
List for further hearing tomorrow.
Yes.
Mr. So and so senior counsel commence submissions. This file. Madam, send this file. Where this file. This one.